much obliged, Your Lordship. The Counsel is here in the matter of National Investigation Agency versus Mr. Sharma and others on behalf of the respondents, that is Mr. Sharma and others. With your permission of Your Lordship, the Counsel would like to state the jurisdiction. The Counsel has approached the Honorable Court under 226 of the Constitution of India. The Honorable High Court of Delhi has jurisdiction under the Indian Penal Code 1860 and the Unlawful Activities Prevention Act for scheduled offences that extend throughout the National Capital Territory of Delhi as notified by the central government in Gazette of India published on April 19, 2010 under powers conferred by subsection 1 of the section 11 of the National Investigation Agency 2008. If Your Lordships are well versed with the facts of the case, may I begin with the arguments? Statement of issues. Your Lordship, the Counsel will deal with two issues: jurisdictional issues, whether the Special Court of Delhi Sessions Court has jurisdiction to hear the case, whether the transfer of investigation from Delhi Police to the Anti-Terrorism Squad and subsequently to the National Investigation Agency was legally justified, whether the offences committed fall under the purview of federal investigation, thereby warranting NIA jurisdiction. And the second issue, criminal conspiracy and liability of the accused, whether procuring SIM cards and facilitating a meeting with the co-conspirators is sufficient to establish Sharma's guilt under the conspiracy laws, whether the accused can be held liable under section 120B of the IPC for criminal conspiracy, whether the allegations against Arvind Mehra and other co-accused fulfill the legal requirements to be charged under terrorism laws UAPA 1967. And my co-counsel will be dealing with the issues, issue number 3 and 4, application of UAPA and strength and admissibility of the evidence. With your permission, the Counsel would like to proceed with the arguments. Mr. Obliged, Your Lordship. It is humbly submitted to the Honorable Court that the respondents challenge the jurisdiction of the Special Court in Delhi and the involvement of the NIA in the case. The Special Court of Delhi does not have the jurisdiction to hear the case under the IPC and UAPA. There has been UAPA misapplication. The NIA has failed to approve the terroristic intent or conspiracy to commit a terroristic act, which is essential for invoking the Unlawful Activities Prevention Act. The evidence presented is insufficient, relying on suspicion rather than concrete proof. The NIA is attempting to expand the UAPA scope beyond its intended purpose. I'd like to cite here the case law, National Investigation Agency versus Wadala, as we have mentioned in the compendium that we submitted just now. The Supreme Court judgment emphasized the need for a prima facie view of the evidence at the stage of framing charges. I'd also like to cite the Tawa Counsel versus Union of India 2021 case, which addressed the issue of bail under the UAPA and the interpretation of membership of a terrorist organization. So next I would like to summarize that we strongly contend that this case has been mishandled from the outset. The NIA's attempt to invoke the UAPA is a gross overreach. They have failed to provide concrete evidence of any terroristic intent, relying instead on mere suspicion. The evidence presented is insufficient and the NIA is attempting to apply the UAPA to what is essentially a matter of ordinary criminal law. Furthermore, the transfer of this investigation from the Delhi Police to the ATS and to the NIA was arbitrary and unjustified. The Delhi Police was perfectly capable of handling this matter. The NIA's involvement is an intrusion on state police powers and a violation of federalism. The offences alleged do not fall under the NIA Act's scheduled offences. With your permission of Your Lordship, the Counsel would like to go ahead with the second issue. The prosecution's case rests on a flawed interpretation of our actions. Procuring SIM cards and facilitating meetings in isolation does not equate to criminal conspiracy. There is no evidence that we had knowledge of any criminal intent or that we entered into an agreement to commit a crime. The appellant has failed to establish the necessary meeting of minds required under section 120B of the IPC. Furthermore, the attempt to charge us under the UAPA is a gross misapplication of the law. Our actions do not constitute a terrorist act as defined under the UAPA. There was no intent to cause widespread fear or panic. and there is no evidence of our involvement in a terrorist organization. Regarding the other IPC charges, the prosecution has failed to provide sufficient evidence of our direct involvement or mens rea. They are attempting to stretch the fact to fit their narrative. We maintain our innocence and assert that the prosecution has failed to prove our guilt beyond a reasonable doubt. We respectfully request that all charges be dismissed. The counsel seeks permission to call upon my co-counsel for further submissions.
With due permission of the Lordship, the counsel would like to go ahead with the third issue, which is against the application of the UAPA. The respondents argue that the act of intimidation, extortion and murder do not constitute terrorism. We argue that there is a lack of intent to threaten India's security. We emphasize the absence of intent to strike terror in the general public, stating their actions were targeted. We deny any connection to the terrorist organization or gang. We highlight the insufficient evidence of terrorist acts. We point out procedural irregularities in the application of the UAPA. The counsel would like to cite the relevant cases, that is National Investigation Agency versus Zahur Ahmed Shah Batali, Arup Bhuyan versus State of Assam, the State of Kerala versus Rajasthan. The placement of explosives do not qualify as terrorism, as there is a lack of intent to threaten national security. The counsel deny any connection to a terrorist organization or gang. We argue that UAPA provisions do not override IPC in this case, as the principle of specific versus general law stating the IPC is sufficient. We argue that the lack of overlapping offences and the UAPA should be an exception, not the rule. Your Honor, we strongly assert that the UAPA is being misplaced in this case. The acts of intimidation, extortion and murder, while criminal, do not meet the stringent definition of the terrorism under the UAPA. Our actions were motivated by a personal gain, not a desire to the terrorism under the UAPA. The placement of explosives were targeted act and not a widespread threat. We are not a member of terrorist organization, and the appellant has failed to provide sufficient evidence to prove otherwise. The IPC provides adequate provisions to address the crimes, and the UAPA strict provisions should be reserved for the genuine threats of the national security. We request the UAPA charges to be dismissed and this case be tried under the appropriate provisions of the IPC. With due permission of your Lordship, the counsel would like to go ahead with the fourth issue, which is regarding the strength and admissibility of the evidence. The respondents challenge the admissibility and the strength of the evidence presented by the NIA, arguing that weakness of the NIA evidence showing that CDR only show communication, not criminal intent. The IPC laws are easily manipulated and do not prove the user's identity. Witness testimonies are unreliable due to potential biasness, memory lapse or influence. The NIS evidence is primarily circumstantial and lack corroboration. The counsel would like to cite the relevant cases, that is Anwar TV versus PK Bashir and others, stating that this case sets out strict guidelines for the admissibility of electronic device, including IT logs, and Sharad Chand versus State of Maharashtra. The respondent challenges to witness statements stating that the question of credibility and reliability due to potential bias or pressure. We highlight the issue of hearsay evidence. We question statement for accomplice or statements given under pressure. We question that the statements that lack personal knowledge. Your Honor, the evidence presented by the NIA is fundamentally weak and inadmissible. The call records and IP logs provided no concrete proof of criminal intent involvement. appellant has failed to establish a prima facie case against the issue, grant the bail to the accused as continued incarceration violates Article 21 to quash the charges under UAPA as the alleged acts do not constitute terrorism under the UAPA of Section 15. Allow the accused to turn approval under Section 272 of BNS 2023, considering that the accused is expressed willingness to cooperate and provide critical testimonies against the mastermind who is Ambedkar. Direct the appellant to present stronger evidence, ensure that the accused is granted a fair trial, pass any orders that the Honorable Court may deem fit and justify the interest of the justice, and for this act of kindness, the respondent shall be ever duty bound and faithful.
Before that, you said there is no flight risk. On what basis you are saying so?
So because he has been a police officer, served the country and been to the police departments for so many years, and he is deeply connected to the society. So he has been stayed for a lot of years here, and the court may see any conditions to report, regularly visit the police station, or be in a house arrest or any kind of fit, or surrender the passport. He is not connected because he is connected deeply in the society, and he is a family member, or the only family member for his family. Yes. Therefore, in the light of facts, circumstances, and legal submissions made above, the Counsel respectfully pays before this honorable court the present appeal be allowed and accused be granted bail, and any terms and conditions for bail, the appellant be granted bail.
We are reading the prayer clause, right?
Okay. And
Press out.
so
You have argued on the territorial jurisdiction. Can you explain that why there is no territorial jurisdiction for Delhi High Court in this matter? So you are for Delhi High Court now.
So, because as the Moot problem states that the incidents of this conspiracy have taken place outside of the Delhi jurisdiction as well, in a place like Gurgaon, where the jurisdiction does not apply. Therefore, we are challenging the jurisdiction of the High Court.
TP, I got a question for you. TP. The case law, you have given some compilation of the case law. Where you got this compilation, this case law, where you got it from? This compilation of case law.
So, we have taken the case laws from relevant sites and compiled them together.
Which side you have taken?
Indian Qanun.
It's not mentioned in Indian Qanun.
So, we have mentioned the citations in our memorial in the footnote.
Okay. The printout which I have taken is not from the Indian Qanun. It shows that you have taken in what format you have taken it, pasted it, and you have put it on this.
Yes, sir. We didn't compile the whole case laws, but
Yes. You are supposed to, you have to take the case laws from the authenticate source. Even I can understand.
they are taken from the authentic sources, but we have compiled it.
Not from the authenticate source.
So, it is mentioned in our memorials in the footnote.
And you are saying that he is a police officer, right? Yes. And serving for the country. So, is there any proof you have submitted along with the bail application?
only for the
Now, whether your bail application is supporting with some of the documents which is showing that there got some testimonials. Your officer, your accused has got some testimonials that they have served for the country.
the testimony is when he has
Have you annexed any of the documents?
in the memorial no, those
Not in the memorial. This is a hypothetical question.
No.
Whether you have not submitted any of the documents to show it to the court that he has served for the country and has got many testimonies.
No, as of now, no. But
So how the court is going to believe on this?
But Your Worship, if I may granted time.
You are supposed to exhibit the documents showing that his testimonies.
if I can be given a time, I can bring a special evidence officer.
Okay. And no case logs are there?
Case logs are in the map.
Not submitted.
Is it in the map? It is in the map.
That is from that is taken from the okay. Fine. Fine, sir. No, fine.
Counsel lets his case and sex motion to shut down.
Thank you, Dean. Please take your position. So, with the permission of the bench, call the next three.
Team R and Team B. This is Team R, standing for affiliate, and Team B for Respondent. Am I right? On your positions?
Honorable bench, counsel seek permission to refer bench as my lord. So we are filed writ petition under Article 226 of Indian Constitution of India, read with Section 483 of BNSS 2023. The circumstances of the filing application on before the High Court of Delhi is because our client Rajesh Sharma, an honest police officer, is being under bar for last 6 months without having any circumstantial or prima facie evidences. Our client is under the bar. The Rajesh Sharma is a former police officer, dedicated his life to hold rule of law, and our client is currently under the circumstantial and lastly investigation under accused prosecution 6 portray him as a leading citizen and he is under the bar. The statements of facts are such that on 15th of July 2024, the Mahindra SUV was found at the residence of billionaire Mr. Ramesh Kapoor at South Delhi. The main accused, which was found dead at one of the locations located at Gurgaon. But the circumstantial evidences of having the SIM card can't be justified as our client is being the guilty under the given suit. Counsel seek permission to proceed ahead with the issues. Whether the petitioner's continued detention is justified in the absence of substantial evidences. The only allegations against the petitioner are the procured SIM card and facilitated meeting between the victim and co-accused. The Delhi High Court, the Delhi Sessions Court, the Special Court had already said that and questioned the sufficiency of evidences sought stronger proof from the NIA. As per Article 21 of the Indian Constitution, right to life and personal liberty, one's life or the liberty can't be curtailed without the due process of law, which NIA has failed to produce before the court. Mere association or co-accused does not prove the criminal conspiracy, as held in State vs. Navjot Sadhu 2005. Thus, petitioner continued detention is illegal and violates the fundamental rights of the petitioner. Whether the petitioner is entitled to bail given the weak nature of the case against him under Section 439 of the CRPC, now BNSS, the bail should be granted where there is no prima facie case evidences. We have seen in Arnab Goswami vs. State of Maharashtra 2020 case where the Supreme Court of India granted the bail. The bail is a rule and the jail is an exception. Without having any prima facie or circumstantial evidences, there can't be denial of the one's right to move and freedom of expression. Honorable Court in Kartar Singh vs. State of Punjab held that bail should not be denied on mere suspicion without concrete proof. The petitioner has no criminal ascendance, making him eligible to take the bail under the established principle of criminal law. Thus, petitioner is entitled to bail due to lack of prima facie evidence. Now, counsel seek permission to go ahead with another circumstantial fact with co-counsel.
Co-counsel seeks permission to present this. Issue number 3. The petitioner's willingness to turn approval under section 272 of BNSS, entitled him to the special consideration or not. The petitioner here has expressed his willingness to assist in uncovering the true culprits of section. The petitioner here has expressed willingness to turn approval and assist in uncovering the true culprits. Section 272 of BNSS allows the accused to seek a tender of pardon in exchange for a full and truthful disclosure. The Honorable Court must consider this in the light of State of Maharashtra vs. Dhananjay Chatterjee, where the approver's testimony played a critical role in uncovering the justice. Prosecution cannot deny his right to become an approver if it is beneficial to the investigation. The petitioner's willingness to assist in the prosecution must be weighed in his favor. It was quoted by the Sanjay Chandra vs. CBI 2011 Supreme Court of India, 100% Supreme Court. Whether the petitioner's right to fair trial is being violated due to media sensations and high-profile nature of the case. The case has gained national interest attention, leading to the prejudgment and bias against the petitioner. The Supreme Court of India, in the case of Zahira Azbullah versus State of Gujarat in 2006, emphasized that the media trials cannot override the right of the fair hearing. Petitioner is being targeted due to public pressure and despite the lack of direct evidence against him. Thus, the Honorable Court must ensure that the trial and prosecution remains free from undue influence and biases. The last but not the least, whether the prosecution has failed to prove prima facie case under the UAPA and BNSS against the petitioner. The prosecution has invoked multiple provisions of UAPA and BNSS against our client, but has failed to prove the direct involvement into the terrorist activity of our client. Under section 16 of the UAPA, there is no mens rea criminal intent from our client, nor does there was an active participation into the murder 314 charges which are filed under the BNSS. Honorable Supreme Court of State of Tamil Nadu and versus Nalini 1999 ruled that mere association with the conspirator doesn't establish guilt beyond reasonable doubt. Since the prosecution has failed to meet the standard of proof, the case against the petitioner cannot be sustained, and hence the Honorable Court must recognize that the petitioner is being unfairly implemented under the significant legal biases. With this, we plead to our Honorable Court that Rajesh Sharma, our client, should be granted bail under section 439 of BNSS, as there is no direct evidence linking him to the alleged offences, and continued detention violates his fundamental rights to personal liberty under Article 21 of the Constitution of India. Holds that prosecution has failed to establish a prima facie case under UAPA 1967 and BNS 2023, justifying the petitioner's immediate release, allowing the petitioner to turn approval under 272 to further help into the case and ensure that the petitioner is granted a fair trial free from undue media influences and public pressure under Article 4921 of the Constitution for equality. Pass an order to deem fit Honorable Court to deem fit. Also here we seek public the protection of the client from the if he is released on bail with the police officer along with him, so that he doesn't get involved or is allowed to any offences post in the order bail. Thank you so much.
Counsel, may I have the permission to start with the proceedings? In the case of Rajesh Sharma versus NIA, counsel representing NIA will be covering issue number 1, 2, and my co-counsel will be covering issue number 3. Starting with the issues, whether the evidence presented by the NIA is sufficient to establish the guilt of Mr. Rajesh Sharma under the charges framed against him. Lordships, it is well established principle under the law, under the Criminal Act, prosecution must prove the case beyond a reasonable doubt. However, in case involving the terrorism, national security, organized crime, all the circumstantial evidence and the substantial evidence, corroborative evidence, testimony clearly makes the Rajesh Sharma to play a crucial role in this crime. Secondly, Mr. Rajesh Sharma was an active participant. He was not a minor participant in this crime. He was an active participant in this conspiracy. His role clearly established through digital and telephonic evidence. Secondly, facilitating the abduction. Third, prior criminal conduct. Clearly, call detail records, CDRs, confirm frequent communication between the Arvind Mehra, the main mastermind of this criminal act, Arvind Mehra in the days leading to the murder. Secondly, calls were made from Sharma's number to the co-accused were totally recorded in the CDR. Then SIM cards were procured and used strategically to avoid the trace mark. Facilitating the abduction by lordship as mentioned in the proposition as a known fact, page number 2 and second para, if my lordship is with me. The witness testimony clearly states, as per the known fact, witness confirmed that Sharma, a former police officer, deceived Prakash Kumar into believing he was called for an inquiry. Instead, he was handed over to his murderers. And it is a known fact which has already been proved. The act of deceit is misused by the authority officer directly contribute to the crime. Secondly, the prior criminal conduct. The accused was previously dismissed by the police agency force for involvement in illegal activities. His association with the mastermind and his direct role in the abduction clearly states the murder further establishes the intent and criminality. Under section 61 of the Bharatiya Nyaya Sanhita (BNS) 2023, which states that any person involved in a conspiracy is equally liable as a principal offender. Secondly, section 140 of BNS states that the abatement not require direct participation in the conspiracy, but includes act facilitate the offences. Since the accused arranged SIM cards and ensured secret communication between the Arvind Mehra, the mastermind of this case, it was crucial that the execution of the crime has been done with the Rajesh Sharma. The crime involved intimidation, extortion, ultimately murder, which were linked to organized crime. If my lordship come to the page number 13 and last para of our memorial, we have stated in state of NCD of Delhi, Navjot Sandhu, 2005 case. It was a parliament attack case. Although the ruling affirmed that the electronic and forensic evidence, when corroborated, is sufficient to establish the guilt, my lord. And here, the call records, along with the official statements which has been recorded, clearly states that the anti-terror law, the precedent, directly supports our case against Mr. Rajesh Sharma. Therefore, the evidence including CDR's witness testimony, digital footprint, and forensic report establish the accused's direct role in the crime. Coming to the further issue, whether Rajesh Sharma's willingness to turn approver under section 343 of the Bharatiya Nagrik Suraksha Sanhita 2023 should be considered a valid ground for granting him relief. Lordship, Rajesh Sharma was not a minor participant as cleared in the issue number 1. Sharma's willingness to turn approver is not a genuine remorse. It is not for the reformative state, but a clear attempt to escape punishment. Although he was a conspiracy handler, he waited until his bail application was rejected. After his bail cleared, only made his offer when he saw that evidence was collecting against the Rajesh Sharma. Then after my lordship, the purpose of this section 343 BNS, it is to aid prosecution, it is to aid the offenders of minor offenders to testify against the main aspect. Not for in this case, Sharma himself is one of the main conspirators. Granting him the pattern would not against the principle of proportionality. And here, if individual mastermind crimes are allowed to turn approver and escape the punishment, all over the conspiracy will be held indirectly. Here, all over the masterminds will turn as the approver and the co-accused will be held liable for the punishment. Along with the turning approver should only be allowed when the prosecution lacks crucial evidence, my lord. In the case of National Investigation Agency, which is on page number 17, second para, along with our compendium, National Investigation Agency was Zahoor Ahmad Shah, Wadala, 2019. The Honorable Court held that the bail stage, courts must only determine whether the prosecution case is prima facie true. If the allegations are reasonable, bail must be denied. This justifies the special court decision to reject Sharma's bail as the prosecution as already established, my lordship. Sharma, as a dismissed police officer, had a previous misconduct. His past infraction raises serious doubts about the reliability as a witness. Secondly, a person which was having a record cannot be trustworthy. Even though he is being an approver, his testimony will not be reliable. As his request is granted, the risk of injury manipulation is high, my lordship. Concluding is, although my lordship, the Honorable Court has the discretion to grant pardon under section 343, but here in this case, every factor its deep involvement in the crime, the strength evidence, his questionable credibility, and the public interest points to the conclusion that he does not deserve the relief, my lordship. Therefore, it respectfully submits that the Honorable Court should reject the Sharma's plea and ensure that he is liable for the accountable under the full extent of the law. If my lordship permits, we'll start with issue number 3.
If my lordship permits, I will.
May please, the Counsel seeks permission to address the bench, your lordship. Good morning to the honorable bench. It may be the Counsel seeks permission to address the bench at your lordship. The Counsel is appearing before Honorable Court in the matter of Rajesh Sharma and others versus State of Delhi and others on the behalf of the appellant, filing their application under section 483 of BNS 2023. Your lordship, there are 9 issues involved in the present case. The Counsel and co-Counsel will be speaking with effect, issue and prayer hereinafter. The Counsel seeks permission to begin with a statement of facts. May oblige. On dated 15 July 2024, Mr. Ramesh Kapoor, a non-industry, residing with his family and supporting staff in South Delhi, informed regarding on abandoned car parked near his residence. Due to high profile status of his informant, Delhi police took immediate action and seized the same and found 20 sticks of galatine, a high explosive and a threat note. For informant and family would be harmed if non-fulfillment of certain demands. ATS took over investigation for Delhi police and as per their findings, 3 persons are involved in the event. Is that dismissed police officer, that is Rajesh Sharma and Arvind Mehra, and a businessman for Bhopal. Case was transferred from ATS to NIA during investigation on dated 18 July 2024. Mr. Prakash going missing on dated 21 of July 2024. His dead body was discovered in the river near Gurugram. On dated 5th August 2024, NIA arrested Rajesh Sharma along with the other accused. Issue the said matter. That's my point.
Hello. Your Lordship, due to limitation of time, I would like to continue the co-counsel seeks permission to continue the facts. Your Lordship, I would like to hello. On 5th of August, NIA arrested Mr. Rajesh Sharma along with 9 accused on the charges of extortion, threat, extortions, criminal intimidations, where the charges from which 9 of the accused were co-accused and the prima facie was against Rajesh Sharma. And on the 5th of August 2024, the bail was rejected for the first time when the accused was in custody. I would like to frame the issues. Mainly, due to the limitation of time, I would like to have a view on issue number 2, issue number 4, and issue number 5. Issue number 2 seeks whether the facts otherwise relevant are relevant. So I would like to refer the section 9 of Bharatiya Sakshi Adhikam 2023. It states that the existing or non-existing of a fact may lead an crucial point in proceedings and investigation as per the criminal law. issue number 2, kindly refer to issue number 4, that is whether a person willing to approve a tender of pardon is permissible under provisions of BNSS. So yes, as per the section 343 under chapter 5, a tender of pardon can be approved for a accused if he is revealing true and full disclosure of a crime scene with his best knowledge. My lord, point to be noted. Issue number 5, person disclosing existence of a fact of any fact has a liability to prove the same. So I would like to, on the prosecution side, they have failed to submit evidences against my client number 1, appellant number 1, which is Rajesh Sharma, as they have given the substantial evidences are framed against prima facie, and yet none of the facts have been proved. So they should approve the facts rather than framing the charges on the appellant. So for issue number 1, my lord, I would like to proceed further for the prayers. As per the section 483 of BNSS, we would like to grant the bail for appellant number 1 as lack of evidences and there are no concrete evidences yet submitted. As the court records, CDR records, and an involvement of a client is being shown against my appellant number 1. Yet they have not proved any of the facts involving 9. Just they have framed because due to the rivalry of the police officer is a dispute officer, they are having their personal interest in the case, and my client has been charged under heinous sections which are applicable under UAPA, which is section 16, section 18 and section 20, which states about the conspirator and the involvement of a member in terrorist attack. But none of the charges are being framed, none of the evidences has been provided from the prosecution side, and the first bail was denied in the special court just on the ground that they need some time and my appellant would tamper the evidences. Yet 40 days have been passed from the custody, from the arrest of my client, and no evidences are being submitted. So it's my humble request to the Honorable Court to grant the bail under section 483. Section 343 as a tender of pardon, which states that the power to High Court and the Court of Session has the power to grant the bail as a tender of pardon, and also there is also my client is willing to become approver and reveal all the truths. And my lord, court may pass order as they think fit. Thank you.
One question. You said charges not.
Charge sheet has been filed when whatever the sections have been framed against my client, yet none of the substantial evidence are being proved, and they are stating in the lower court that there is a concrete evidence and all the facts which are being framed under the is being made only a prima facie. In the first instance, there are two criminal instances. First was a complainant who has informed about the car which has been abandoned car found beside his resident. Okay, and that when the car was seized by the Delhi police, at that time there is no video conferencing. As per the new BNSS law, there should be a video conferencing at the time of seizure. No evidences has been provided like fingerprints or CCTV cameras. No footage has been provided by the prosecution. And threat note was found. So considering the evidences as per new law, no reports has been filed under section 65B. No certificate has been given for the CDR call details yet. This was the first instance, and after when the NI court came to know and investigated that the appellant is a prima facie, the accused victim Mr. Prakash Kumar, gone missing on 18th of April. And after 3 days, the NIA got dead body found near river Gurgaon. So from date of 15th July to date 21st of July, it has been 6 days. And the NIA was and prosecution was waiting for the date to find the body of a victim. Rather than searching him or rather than finding a crucial point which can investigate by the NIA, federal agencies involved, ATS is involved, and police officers are involved, all the high authorities, state authorities, and
Charges not framed, right?
charges are framed, but none of the evidences are.
Proceed with the grounds of granting the bail, as the Honorable Bench is already aware of the statement of the facts as well as the statement of the jurisdiction. Now, there are various grounds which the Council would like to rely on in order to grant bail to my client. The first and foremost is the absence of substantial evidence in this particular case. The enacted case against the appellant is largely based on circumstantial evidence. Primarily, the call details, that is CDRs, the IP logs, and the procurement of SIM cards.
Sound arrangement.
Mic check.
Please start. Thank you. Just starting. Yeah, without permission of the lordship. Start. Well,
Am I audible, sir? With permission of the bench, may I start again, please? The first and foremost, the ground that the Council wants to rely on is absence of substantial evidence. The NIA's case against the appellant is largely based on circumstantial evidence, primarily on CDRs, IP logs, and the procurement of SIM cards, which by themselves do not establish Rajesh Sharma's direct involvement in the commission of the crimes that he has been alleged under. There is no direct evidence linking the appellant to the actual planting of explosions or the murder of Prakash Kumar, the deceased in the case. The allegation against has remained speculative, and there is no strong or cogent evidence establishing him as the mastermind or a key player in the conspiracy. I would like to draw attention of the bench on the details mentioned under the Moot Court problem, wherein the Delhi High Court itself, during the hearing, questioned the NIA about the evidence that they had gathered to substantiate the claim against Rajesh Sharma, who was mentioned as part of the conspiracy. Despite the initial presentation of evidence, including call records and witness statements and panchanamas, the court has expressed their reservations of a strong case against Mr. Rajesh Sharma. NIA could only find Sharma's involvement procuring him SIM cards, facilitating the victim's meeting with the co-conspirators, which was insufficient to prove the guilt. The court has emphasized that for accused Sharma to remain in custody, the NIA should bring more evidence in support of their argument of involvement of Mr. Sharma in the conspiracy and his direct involvement in the murder. Moving on, there is no direct evidence linking the appellant to the actual planting of explosive or the murder of the deceased Prakash Kumar. There is no legal connection with the act of murder. The appellant is accused of merely facilitating a meeting between the victim Prakash Kumar and the co-conspirators.
his role as per NIA is alleged to have been limited only procuring to the SIM card. There is no evidence to suggest that Mr. Sharma had had any motive to murder Mr. Prakash Kumar, who is deceased in the case, or was directly involved in the actual execution of the crime. Another important ground that counsel wants to rely on is apparent willingness to cooperate and become an approver in the case. Now, Mr. Sharma has shown his willingness to become an approver and cooperate with the investigation voluntarily, that too might I add, and he has already tendered an application seeking pardon and
to be believed the main suspect of this offence. My Lordship, under section 43B, 43D, subclause 5 of the UPA says that bail cannot be granted if the court believes that the accusation against the person are likely true. The evidence against Sharma, such as witness statements, phone recordings, and his connection with the main accused, shows a strong case against him. Also, in his second trial witness, Sharma asked for the bail under section 343 of BLSS by offering to become an approver. Simply by saying that he wants to be an approver doesn't mean he should be granted a bail. If bail was granted just because of someone offers to be an approver, it would be dangerous. The special court's rejection to Sharma bail is justified under the seriousness of crime and charges related to terrorism, and also the legal restrictions on bail under UAPA. Also, the risk that it could be tampered with the evidence. Strong prima facie cases established against him. In conclusion, I would like to say that the special court decision to deny bail is legal and correct. Sharma must stay in custody to protect the fairness of the judicial process. If my lordships are satisfied, I would like to start with the prayer. The respondent.
One question. You said that you should be granted police protection to prevent further crime. How do you say that?
Not for further crime, but since it is the nature of high interest and stakes from the behavior itself, he is a prime convict into the case. He should be provided with the payroll, but at the same time, he should be along with accompanied with a police officer for his protection also.
In case his application to serve as an approval is allowed.
Yes.
Right?
Yes.
Not until then. Even if he is granted bail, no protection.
No. Because then he is not a subject of he will not become.
What about the misconduct, previous misconduct versus your application for bail? The prosecution is arguing about the previous misconduct and his suspension.
So previous misconduct, so there is a maxim which is party. No one should be vexed twice for the same, under which we can justify that thing also. He may be accused into some cases which are still pending, but as justifying him from that case and bringing it here in the same court will not uphold the justice.
On what basis you are saying that his testimony would not be relied in case his application to approval is granted?
Lordship, as per the prior criminal conduct, he was already having a criminal intent. And secondly, before that he was not about to give any statements. But after when he got to know that he is getting already against evidence, then after he claimed for the approval. And secondly, the statement, the digital evidence or the facilitating abduction, all over the criminal intellect is clearly states that he can anyway, be hostile in anything, in any evidence which, or any statement which has been given.
What about the past misconduct? What we are saying is that that should not be considered while considering the way. What do you say about that?
Although the past offense will not consider, then too we are having the digital and telephonic evidence, then we are having the clearly testimonies which we are stating. So here the circumstantial chain which has to be created, it is already created. Even though we are not taking the past criminal offences, then too the circumstantial chain is already created. And here we cannot ignore the fact that he is a suspended officer with all those offences which have been mentioned as per the proposition.
Thank you, Dean. Thank you, take your position. With the permission of the Lordship, I'd like to call next team of.
So it is a settled principle under criminal law that an accused can only be detained when there is prima facie evidence of his involvement in the commission of the crime. The absence of strong and consistent evidence does not justify the continued detention of the accused. Here, the accused presented so far is circumstantial, which is insufficient to hold the appellant in custody. So, Honorable Apex Court in the category of the judgments, namely K.K. Verma versus Union of India, Menka Gandhi versus Union of India, Sultan Singh versus Union of India, and State of Punjab versus Darshan Singh, has held that detention without sufficient evidence violates the right of personal liberty under Article 21 of the Constitution. The Council would move on to the issue number 2. Whether the facts not otherwise relevant can disapprove the allegation alleged against any person as per the new criminal law. The facts presented by the prosecution must be directly relevant to the case and not based on extensions or irrelevant facts. In the present case, irrelevant facts such as appellant's procurement of safeguards have been misinterpreted to disapprove the innocence of the accused. Honorable Apex Court in case laws, namely Ram Singh versus State of Haryana, R.V. Brown, Mohammad Ahmed Khan versus State, and State of Uttar Pradesh versus Rajesh Gautam, Court has held that facts which are not directly connected to the crime cannot be used to disapprove the innocence of an accused. Court held that evidence must be considered directly to the crime and not based on extraneous facts. Council, with permission, can I move on to the issue number 4 and 6? Whether there is any provision for an accused person willing to become an approver to give justice to the victim as per new criminal law. This law allows an accused person to become an approver, thereby providing truthful evidence against co-conspirators. In the present case, appellant has shown willingness to testify truthfully and assist in the case. In the present case, the Sharma had agreed and showed willingness to by signing a letter to become an approver. We'll move on to the issue number 6. Whether fabricating false implications imposed by a person in maintenance without concrete evidence. False implications cannot be form the basis for a criminal charge unless they are supported by substantial and admissible evidence. Fabricated evidence cannot be sustained under law. Can I conclude with a prayer, please? Whereof, in light of the facts stated, issues raised, arguments advanced and authorities cited, the appellant, I humbly pray before the Honourable Court that it may be pleased to, that this Honourable Court be pleased to enlarge the appellant on bail under Section 483 of Bharatiya Nagrik Suraksha Sanhita 2023.
I am appearing as counsel on behalf of the respondent. I am along with my co-counsel and researcher are representing the respondent in the present matter. I will be addressing issue number 1 and 2 while my co-counsel will handle issue number 3 and the case summary. Your Honor, with your permission, I would like to proceed with arguments on issue number 1. Much obliged, Your Honor. Issue number 1, whether the denial of bail to the appellant Rajesh Sharma is justified in the light of the insufficiency of direct evidence linking him to the conspiracy and murder of Prakash Kumar. Your Honorable Bench, the denial of bail or to the appellant Rajesh Sharma is legally justified as the prosecution has established a strong prima facie case against him based on circumstantial evidence linking him to the conspiracy and murder of Prakash Kumar. Second, the evidence against the appellant forms a continuous chain directly connecting with him to the conspiracy. Eyewitnesses testimony, a police officer testified that Sharma misled him to arrest Prakash Kumar, facilitating his abduction. Call detailed record show that Sharma was in regular contact with Arvind Mehra and other accused before and after the crime, indicating his active involvement. This is supported by the Supreme Court's ruling in state of UP versus Amramani Tripathi. This is reported in the year 2005 in the volume 8 of the Supreme Court Cases Reporter at page 21. Sir, the risk of witnesses tampering of high, given his background as a former police officer, Sharma is in a position to influence key witnesses, justifying denial of bail. The gravity of offence demands a stringent approach in NIA versus Jahur Ahmad Shahabatali. This case reported in the year 2019 in volume 5 of Supreme Court Cases Reporter at page 1. This Honorable Court held that in cases involving conspiracy and organized crime, bail should not be granted unless the accused reverts the prima facie case which Sharma has failed to do. Your Honor, with your permission, I would like to proceed with argument issue number 2. Much obliged. Issue number 2, whether the prosecution has failed to establish a prima facie case under the UAPA Act 1967 and Bharatiya Nyaya Sanhita 2023 warranting continued incarceration of the appellant. Sir, legal at the bail stage. Under the UAPA Act 1961, the court does not assess guilt beyond a reasonable doubt but only consider whether a prima facie case exists. Again, same case, NIA and Jahur Ahmad Shah Batali. Your Honor, with your permission, may I proceed with my submission? Much obliged. Your Honor, planting explosives to intimidate and exhort clearly falls under Section 16 of the UAPA Act 1967, which punishes Terrorist Act
Additionally, the appellant role in the ensuring the victim's presence and aiding in this his abduction makes him liable under section 18 for the conspiracy or to commit a terrorist act. Criminal liability under Bharatiya Nyaya Sanhita 2023, section 61, criminal conspiracy, where the appellant actively conspired with the main culprit, assisting them in executing their plan. Section 103 and section 61 subsection 2, murder with common intention. Even if he did not execute the murder, he facilitated it, thereby attracting liability. Section 140, abduction for murder. His role in ensuring the victim was delivered to killer establishes culpability. As section 43, subsection 5, 43D, subsection 5 of the UPA Act 1967, Act strictly limit bail unless the accused proves there is no prima facie case. The appellant has failed to do so. In K.A. Najib versus Union of India, this case reported in the year 2021 in the volume 3 of the Supreme Court Cases Reporter at page 713, the Honorable Court had held that delay in trial alone is not ground for bail in UAPA Act cases. Here strong evidence links Sharma to the crime, ruling out bail. Your Honor, this concludes my submission. I would request two co-counsel to proceed with issue number 3 and case summary.
With due permission of the Honorable Court, I would like to proceed with arguments on issue number 3. Much obliged, Your Honor. Whether the appellant, having expressed willingness to turn approver under section 358 of the DNSS 2023 is entitled to bail or any other relief under the law. Turning approver does not guarantee bail. In the case of C. Chenga Reddy vs. State of AP 1996, courts have ruled that just expressing willingness to become an approver does not entitle an accused to bail. Before granting him relief, there must be verification whether Sharma's statement is truthful and whether he is genuinely remorseful or just trying to escape legal consequences. Until a pardon is formally granted by the court, he remains an accused in a grave offence and cannot be released. If released, Sharma may try to flee or manipulate the evidence, making it imperative to keep him in custody. While Sharma has expressed willingness to become an approver, under section 358 of the DNSS, mere willingness does not entitle him to bail. Sharma's willingness to turn approver does not automatically entitle him to release. The court must first determine the credibility of his testimony, whether his testimony adds value beyond the existing evidence. In the case of State vs. Abu Salam Abdul Qayyum Ansari of 2010, volume 10 of Supreme Court Cases, page number 179, the court ruled that an accused seeking pardon must first demonstrate full and truthful disclosure before being considered for leniency. If released, there may be possibility of retracting statement and risk of absconding. If released, Sharma may retract his statement, rendering his testimony useless. With due permission of the Honorable Court, I would like to present the case summary.
As a former police officer, Sharma could influence and intimidate key witnesses and could manipulate evidence if granted bail. Courts have repeatedly denied bail in cases where the accused could interfere with the investigation. Section 43D5, subsection 5, states that bail should not be granted if there is prima facie case.
One question. You said testimony would become useless. Under what provisions? In case bail is granted, the accused is likely to retract his statement and the testimony would be rendered useless. That is what is your argument. On what basis you are arguing that?
He may tamper the evidence after he has been given bail.
There may be a case law which you are different from that what is your side.
Yes, under repetition, under the violation of fundamental rights.
Under provision?
If the trials are ongoing, we can approach for bail in High Court under writ petition for violation of fundamental rights, and if the trials are being judged, then we can appeal in High Court for first appeal. And under Article 136 special petition, we can also approach for Supreme Court UAPA.
May Your Honor please repeat your question?
That in case he is being released on bail, he may retract his statement and his testimony would be useless. That was your argument. So I am just asking based on what you are saying. That is authority. Whether
in the case of R.K. Anand versus Delhi High Court of 2009, Volume 8, Supreme Court Cases, page number 106, the court emphasized that witness protection and judicial control over an approver are crucial to prevent manipulation of justice.
But their argument is that approval should be granted bail. So that will go against you.
The approval must be granted bail. Yes, but the approval was a former police officer, which means he may tamper evidence and he may he can influence witnesses and manipulate evidence.
My lord, this is the statement given by every respondent. Can they prove it's been 40 days from the date of arrest, that is 5th of August, my client was arrested, and 40 days what you are doing from that. So if he is in custody, yet he has not tampered. So why cannot we find the evidence against, concrete evidence against my client? So can you justify the statement?
What case law she is different? Are you aware of that?
Yes.
The Anand case law is there with you?
Sir,
have you gone to the Anand case law? You got a case law because you have not submitted any case law. So you think you have not took that case law? No? You different having case law of things, right? Have you gone through it? Only just submission from the Google.
Thank you, Chief, for your arguments and whatever arguments you have put up. Thank you. So, with the permission of the bench, I'd like to call next team. Our next teams are Team N for the petitioner and Team A will stand for the respondent. Team N stand for petitioner and Team A stand for respondent.
Issue 3. Your Lordship, this will please the court, the NIA stand before you firmly opposing the bail application of Rajesh Sharma. The Honorable High Court possesses the jurisdictional authority to adjudicate the bail application appeal given the gravity of the offence, which include the act of terrorist, conspiracy, implication, national security within the Delhi jurisdictions. This is the second bail application. First application was rejected by the special court and the trial is going on. By rejecting this bail, the accused find before the Honorable High Court. If the Lordship is well versed with the legal emphasis, Counsel seek permission to go directly on the issue number 1. Issue 1 is whether the rejection of the Rajesh Sharma bail applications was legally justified and in line with the principle of fair trial and presumption of innocence. The core issue here is whether the special court decision was legally justified, balancing the presumption of innocence with the gravity of the offence and the evidence presented. The gravity of the offence demands strict scrutiny. Sharma is charged with the murder charges 103 of BNS and the criminal conspiracy under section 61(2) of BNS and the terrorism related offence under the Unlawful Activities Act 1967. The State of Maharashtra versus Anand Chintaman DK 1990, when the offence impact public order court must exercise caution in granting bail. The second one here, the strength of the prima facie evidence is substantial. NIA have heard detailed record, eyewitnesses, testimonies, evidence of Sharma's procurement of the SIM card used in the conspiracy. Your Lordship, please refer memorial page 16, wherein P. Chidambaram versus Judicial of Enforce, the Supreme Court emphasized that grave offence involving conspiracy requires the strict bail scrutiny. There is a significant risk of witnesses tampering Sharma, a dismissed police officer, retained influence. State of UP versus Anmani Tripathi 2005, 232 BNS, bail can be denied when there is a reasonable appreciation of the witness influence. The national security implication under UAPA cannot be ignored. In section 43B5 impose strict bail condition. NIA versus Wadala, page number 19 in memorial. The Supreme Court states assessing the prima facie truth of allegations in territorial case before the granting bail. Learned Counsel just now pointed out that the Sharma offered to turn approval under section 272 of BNS does automatically warrant bail, does not automatically warrant bail. In Sarwan Singh versus State of Punjab, approval statement requires strong corroboration. If accused was not involved, then he would have no information to give. In conclusion, the rejection of the Sharma bill is justified due to the gravity of the offence, strong prima facie evidence risks of witness, tampering national security concern, and the lack of bona fide in the approval offences. If the court is concerned with the first issue, the Counsel seek permission for the issue number 2, whether the evidence presented by the NIA is sufficient to establish Rajesh Sharma's involvement in the conspiracy to murder, also for threatening the intimations, extortions of the Mr. Kapoor beyond a reasonable doubt. The respondent submit that the Rajesh Sharma involvement is clear and compelling. His involvement in the conspiracy of the murder of the Prakash Kumar is supported by the CDS, witness testimonies and the procurement of the SIM card. Section 61 and 61 subsection 2 BNS 2023 protecting the criminal conspiracy are directly applicable. State was in Navthur, page number 50 in the memorial. Called detailed records are admissible evidence to prove conspiracy when corroborated. State of Maharashtra versus Somnath Thapa 1996 clarifies that the knowledge of illicit act is crucial for establishing conspiracy. Sharma's role in Prashant Kumar murder is evident in section 314 of the regarding murder along with the sections conspiracy kidnapping, causing disturbance of the evidence.
Reliance was placed on the Wadala case, Your Lordship, but this case, the facts, Your Lordship, are very similar to this case because the bail was rejected and the evidences were the CDR, Your Lordship. In this particular case, I have produced, Your Lordship. Now, let me just come to the circumstances how this particular law, the provisions are applicable in the current state, Your Lordship. So, Lordship, first of all, we have to understand the significance of the circumstances, Your Lordship. Now, the first of all, on the 15th July, the explosives were found, Your Lordship. Now, we have to understand where they got found and on what date. 15th of August, Your Lordship, is a very huge day in Delhi and in India, Your Lordship. Many security persons were there, Your Lordship. And in that moment, within a 1 month before the Independence Day, this explosive got recovered in the South Delhi, Your Lordship. In the South Delhi, there are many prominent diplomat officers are there. There are prominent politicians are staying, Your Lordship. Even parking a vehicle is very difficult, Your Lordship. And we got explosives which are concealed in the backpack in that South Delhi, Your Lordship. So, when the first case was handled over the police investigation, Your Lordship, by the Delhi police handled the case first of all. They came to know about the owner of the vehicle, Your Lordship, and they were tracing the owner, Your Lordship, which was a businessman, Mr. Kumar, from the Mumbai. And when they were tracing the case, on 18th he got missing. It was reported, Your Lordship, it's there in the facts of the case. Now, Your Lordship, on the 21st, he got murdered. The body got recovered. Now the case got transferred to the ATS. Till the body got recovered, ATS was handling the case. But Your Lordship, considering the situation, because it was a high security area, dates, Your Lordship, just 1 month because when the whole India is on high alert, the explosion for. So NIA has to investigate this matter because it is related to the national security, Your Lordship. We have to consider the circumstances and their evidence. Later, Your Lordship, when NIA got investigated this particular matter and it was tracing back to Mr. Kumar, that time the last conversation happened between Kumar and Sharma. And then NIA get investigated regarding the call and call details and came to know that there was a SIM card which was constantly calling this particular Kumar. And then we got the CDR reports, Your Lordship. Then we got the IP logs, and because of that suspension, we arrested the Sharma on 5th of August, Your Lordship, just 10 days before the Independence Day, because it was very necessary to understand what is the depth of this conspiracy, Your Lordship. Later on, Your Lordship, it was after the investigation, we also arrested few other individuals who played an important role, Your Lordship. So this evidence are important, also the circumstantial evidence when we talk about. We have to understand what is the circumstance behind this particular evidences, Your Lordship. Next, Your Lordship, I would like to emphasize on that. Now, Your Lordship, detonator was not found in the backpack. 20 electric stick for detonator was not found. Only the threat note was found, but it was not directly delivered to the particular person, that is a businessman to whom it was intended. So the NIA investigation is going on with the permission of the special court. There is a provision for it because we believe some other terrorist organizations are behind this. And only a person having a detailed knowledge of the securities and the routes in the Delhi, where Delhi police, ATS, RAW, NIA, everyone is present for the security arrangement. Only that person can get a Bombay registered vehicle in the Delhi, Your Lordship. Next, Your Lordship, to investigate the matter, it is very important to understand who is the key conspirator, Your Lordship. The Mehra, who is a dismissed officer. And he met Mr. Sharma, who is again a dismissed officer. Their conduct is very important, Your Lordship. As per the Evidence Act and as per the new Bharatiya Sakshi Samhita, that their gross misconduct is the reason for the dismissal, Your Lordship. These persons have acute knowledge of the internal security provisions, Your Lordship. They met in the police headquarters, Your Lordship. So we believe that there is a larger conspiracy which is going on and we have to tackle that, Your Lordship. That's why we have arrested the Sharma. We filed a charge sheet within the time limit, Your Lordship. There is no procedural law. So a default bail will not arise, Your Lordship. Here the only chance are there that if there is a delay in this particular trial, only that case, Your Lordship, we agree. There is a case law and there is a settled case law, Your Lordship. However, Your Lordship, charge sheet already been filed. The court has taken the cognizance of that particular charge sheet, Your Lordship, and it's a special NIA, Your Lordship. I am submitting a particular gazette where special court has been established. Every day they are conducting a trial. Just because they are coming to the High Court, because High Court has inherent power and concurrent power regarding the bail application, the speedy trial is pending, Your Lordship. Once the Honorable Court will decide, the trial will resume, Your Lordship. So, Your Lordship, these are my contentions that because the circumstances were like that,
And we, based on the circumstances, we have a very strong case and a prima facie case made out. And because the prima facie case out and because of the previous precedent, Your Lordship, the bail cannot be granted because it is a matter of national security. When you have to choose between the fundamental rights provided by the Constitution of India under Part 3, even under the Article 21, and we have to decide between the national security, we have to give the weight to the national security, Your Lordship, because we believe this explosive can be detonated later on, Your Lordship. It can create a deeper impact. This threat note, Your Lordship, obviously they have a legal name. Your Lordship, considering the primary accused and the excellency level, it was not a well executed plan, and I believe it was caught at the preparation level, it should Lordship, rather than a commission level. So investigation is going on, is justified, Your Lordship. We have to consider all the factors while ending the investigation. We cannot just hurriedly complete the investigation, Lordship. Based on the Lordship, I give to my co-counsel regarding the pardon applications which I have filed. He will argue on that. Much obliged, Your Lordship.
I am Pooja number 2 for the team A. Your Lordship, may I begin with the issue 3? Whether Sharma is entitled to a pardon as an approver under BNSS Act. Your Lordships, I humbly submit that Sharma is not entitled to a pardon as an approver under BNSS Act section 343 and 344.
Of being involved in the terrorist activities and has been charged under sections stated in the fact sheets. Primarily, we would like to start by saying that Sharma is innocent and not a threat to society, and these charges against him are fabricated without reason. Also, Sharma neither resorted to violence nor has he incited anyone to violence. Further, this act of some fictitious organizations and its conspiracy. Further, rejecting the claims made by the state. The chain of circumstances has been established is nothing but far-fetched, and Sharma has no motive, no means to murder Kumar to take part in any conspiracy. So there are no circumstances that warrant conviction under any section. Furthermore, I would like to cite the case of Pradeep Sharma versus NIA, which is in the compendium flag 1, page number 139. This case is almost similar in the facts, and the law is to present, where the Supreme Court had granted bail to the key accused, and with utmost respect, we request the court to follow the same rule. It is my humble submission that there exists no prima facie evidence to establish any involvement of Sharma and the said to the said conspiracy. The only evidence that NIA has is relying upon to connect Sharma to the conspiracy in the SIM card's procurement to establish even a minor role. A lot of things and like criminal intent, knowledge of crime, etc. are required to establish without even a shadow of reasonable doubt. Hence, my lord, it is my humble submission that there is no prima facie case that warrants dismissal of the application and hence grant of bail. Now further, my lord, I would request to go ahead with the discharge application. The discharge application has been given to you because to discharge the charges of Mehra and Sharma, the applicants is being made under section 262 of BNSS. The grounds of the discharge applications are also stated in the discharge applications. The applicants are innocent and has been falsely implicated in the alleged offences. There is no evidence to connect him with the alleged offences. The allegations made against the applicants are absolutely vague, and also even the section in the charge sheet are incorrect. The section is 167. The evidence does not implicate any involvement of either the accused in any of the crimes. Therefore, I most respectfully submit that this honourable court be pleased to discharge the accused, one, Mr. Arvind Mehra, and second, Mr. Rajesh Sharma. If your lordships are satisfied with the arguments presented, so I would like to call my co-counsel to shed more light upon the present case.
Greetings, my lords. I would be continuing with the bail application, the hearings of the bail application. we only have one major contention, that is that Sharma should be granted bail. In furtherance of the bail application, in the memorial it is annexure number 1. I would like to bring on record that we are not a threat to society, nor do we have the means or motive to influence the trial. Additionally, the NIA has also filed the charge sheet and has concluded its investigation. Furthermore, we are deeply rooted in this city and therefore are not a flight risk. Going ahead, we did not conduct a mini trial but just a prima facie presentation that the charges are incorrect is sufficient for the grant of bail. For this, I refer to Tawa Fasal versus Union of India. This case is referred for the rule and not a specific paragraph has been referred in this case. Under this, the Supreme Court has clearly stated that the court is not expected to hold a mini trial. The court is supposed to examine the merits and is not supposed to examine the merits and demerits of the case, but rather test if the accusations are reasonable at large. Stating this, I would like to touch upon the evidence to illustrate our claims that state cannot make a prima facie case against us. The NIA has only two major so-called evidences against Sharma. Firstly, he misled the police and led Kumar to the people who have murdered him, and secondly, that he has procured certain SIM cards. Relying on this, the state aims to establish that he was involved in murder of Kumar. However, the story is contrary to itself, as any police officer is to know that a fellow officer has been dismissed and not to take orders from such dismissed police officers. Beyond this, the state has also put up the case that Sharma has procured SIM cards that have been used by Mehra in furtherance of conspiracy. However, this statement holds no weight as the evidence of CDRs and IP logs and that have been relied upon is nothing but concocted, and the said evidence in no way can bring anything on record that can be material for conviction or acquittal of either Sharma or Mehra. Hence, my lords, it is a humble submission that the evidence is without logic and which has also been recognized by the trial court. Furthermore, the examination in chief and cross-examination of 300 plus witnesses will make this trial extremely long. Similar has happened in the cases of Athar Parvez versus Union of India and Union of India versus K.A. Najib, where again in both cases key accused had been given bail for the sole reason that the trial would be very long because of the sheer number of witnesses. This has been referred in Athar Parvez para 19, page number 120 of the compendium, and paragraph 17 of K.A. Najib, page number 151 of the compendium. Additionally, my lords, it is our humble request that Sharma be released on bail, as the NIA is using his custodial presence as an unfair practice and not respecting his rights. And they have coerced Sharma into becoming an approver. My lords, we maintain that they are wrongly accused and thus seeking this bail. We do not have any cause or reason to become an approver. On contrary, this turns out to be of advantage to NIA, as such a letter of intent can be treated as a subsequent act, thereby further fabricating evidence against Sharma. Sharma is in custody and in no control of the documents he signs, and therefore we, standing before your lordships, would like to state that the said letter was not made out of free will. In a nutshell, we contend that state has failed to establish any prima facie case as under Supreme Court guidelines in Tawa Fasal, and the length of trial is to be considered for the grant of bail as under Athar Parvez and K.A. Najib, and the breach of rights in prison. Hence, my lords, it is most respectfully submitted that under these circumstances, bail should be granted. If my lords are content with the arguments, we seek to move on to the prayers. We pray that your lordships grant us bail, further issue an order for expedited trial, expedite the case, and any other orders that the court may deem fit. Thank you.
You want to bail or you want to expedite the trial?
At the present stage, we want the bail. However, the trial is still ongoing and to expedite so that we can get acquitted as soon as possible.
Expedite the trial, you will not get the bail.
Then, my lord, we will take bail at this stage.
How you want bail or see, your players are contradictory.
Pardon?
Your players are contradictory. You should ask for the bail only. Here, the case law is for this particular the Moot court competition that the case we have given is for the bail only.
Apologize. Seek bail application. Thank you.
May it please honorable court. We are representing the NIA, we are special public prosecutor. I am Moot number 1, I am the handle issue number 1 and 2 for my memorial, and issue number 3 will be handled by the counsel. Your Lordship, if you are well aware of the facts of the case, can I move to the argument? Your Lordship, the present case, that is the bail application has been instituted under section 480, where Your Lordship, there is a charge sheet which clearly indicates that there are serious offences under NIPA. The previous bail has been rejected, and I would like to bring your kind attention to Your Lordship how the circumstantial evidences are related to the circumstance first, and then what is there in the law and why this bail should not be granted, Your Lordship. Let us first consider what is exactly given into the law, Your Lordship. As the charge sheets, Your Lordship, trial is already going on as per their details. They are well aware of the time is going on. The charges under NIPA, then the particular accused is not been discharged with the charges. So when the charges are there in the charge sheet, Your Lordship, there is a section 43B which gets revoked. Now court, if they have to decide regarding the bail application, Your Lordship, there is a very landmark judgment, Your Lordship, that is the NIA versus Wadala. This case has a significance in this particular case, Your Lordship, because the first time the Honorable Supreme Court interpreted the meaning of prima facie and the scope of the section 43B, Your Lordship. Here, Your Lordship, next arguments I will introduce, and I will prove how there is a prima facie case regarding the circumstances and a circumstantial evidence. But let me just confirm, Your Lordship, that because there is a prima facie case, this particular bail was rejected, and currently also, Your Lordship, we cannot go into the detailed trial, we cannot conduct the mini trial.
Including CDRs, forensic reports and witness testimonies, which sufficiently establish the guilt of Sharma and his co-accused. Your Lordship, may I begin with the prayer? In the light of issues, argument advanced and authority stated, the Counsel for Respondents humbly pleads to the Honorable Court that it be pleased to affirm order by Honorable Special Court rejecting the bail application for grant of bail made by the appellant. Prayer number 2, deny the bail to the appellant as per the provisions of Unlawful Activities Prevention Act 1967. And prayer number 3, hold the charges framed against the appellant under UAPA Act and BNS Act are legally sustainable, and or pass any order or grant any relief as it deems fit in the interest of justice, good conscience, and for the act of kindness, the respondents shall be duty bound forever. Much obliged.
One question. You have made an application under 262 of BNSS. Just as application. Now see the provision where this discharge application can be filed, which court?
My lords, I do understand that the section does restrict discharge application before a magistrate. However, the court High Court always has the power under 227 to exercise this. And if the court still feels that it should not be filed here, we would not mind going back to the magistrate filing it.
Simple question. And your application is under what provision? Whether you have applied under 262 or you are applying under 226 to 27 of Constitution. What is that your provision? You are invoking.
I simplify it. No, I will ask you something.
Yes,
Pardon? In this case, you are going to withdraw your application?
No, I would
say now there are two choices for you.
Yes, ma'am.
One is for the discharge application, or to decide about bail application. What you will prefer? The discharge application or the bail application?
Bail application.
So why you find the discharge application?
bail application has also been filed along with.
Along with. Why is both of these applications like simultaneously? When the bail application is not decided.
Bail at this time, my lords, bail application will always be rejected. It can go either way.
If rejected, then you have to withdraw one application.
It is just
for simultaneously.
At this stage, my lords, we have approached our primary reason for approaching this court has been bail.
Okay.
However, just in case that if, because since you are already here and the court has the power to exercise two bits and already looking at the case.
You are not under you are the 262. What is the SHRI?
Agreed. That is the thing.
You are not under the.
You have to answer one question that they are saying about the 300 plus witness and that will delay the trial. What you say about it?
Your Worship, is it true that the Constitution guarantees a speedy trial because the particular accused in the detention, but at the same time there should be a fair trial, Your Worship? 302 of evidences, witnesses are there and more evidences are there because the level of the constituency, Your Worship, if they are handling multiple states, Your Worship, it is the NIA's duty to bring out the real conspiracy and the real conspiracy, and then only we can decide about the case, Your Worship. So just because there is a provision for speedy trial doesn't mean we have to overlook the unbiased and trial which is expected as per the provisions of CRPC and the UAPA and NIA Act, Your Worship. So 302 witnesses, NIA never went and gathered 302 witnesses particularly, Your Worship, because the particular Sharma and other accusers operated in a various way, in a various method, in a very premeditated plan. That is the reason, Your Worship, there are 302 witnesses available, Your Worship. Now, Your Worship, if we don't try the witnesses, and chances are high that some of the players who have played a key role, which can be more than Sharma, Your Worship. NIA is not denied that. So they will only be under bar, Your Worship, if you just speedy the trials and don't consider all the witnesses, Your Worship. That will be again an injustice to the Sharma, Your Worship, because everyone should be treated equally before the law, Your Worship.
I got one more question for you. Approval is favoring you, right? Becoming one accused, the approval is favoring you. So will you support him for granting the bail?
I understand your concern, Your Worship. I got your point. You're talking about the approval is helping us regarding the investigation.
Suppose the approval is there and he has filed the bail application. You are under the trial. Take these circumstances.
I understand.
This is the situation. Okay. Where the trial is going on, approval is favoring you. By becoming the approval.
Okay, Your Worship. The answer
letter of pardon will be later on stage. Now we are on the part of bail.
I do understand, Your Worship.
So are you going to support the person who is going for the letter of pardon?
I got your point, Your
Who is trying to become the approval?
Allow me to answer Your Worship. Yes, based on the circumstances, if the approval is a key accused, and the whole trial is for that particular key accused, we cannot get into the pardon or we cannot make it the approval, Your Worship, because the provision of the word specifically given the accomplished, Your Worship, not the key accused. There are several judgments also which is currently not by the settled law that key accused cannot be the approval. However, Your Lordship, in certain cases, I'm just giving a hypothetical example, in case of dacoity, if there is no particular evidences are available and some approval is helping the investigation, definitely it is the duty of the investigation. Other accused, if you are helping the NIA, Your Lordship, to tackle the larger case, definitely we will take the help of the approval, Your Lordship.
Will support him for granting the bail?
Debating the bail. Your Lordship, whenever there is an approval, he has to bring something on the table, Your Lordship. What exactly is helping in investigation? If he's really, because chances are high the approval can be the hostile witness, Your Lordship.
We are under the trial now.
Yes, Your Lordship, the approval can be the hostile witness, Your Lordship. But what is bringing on the table, how is helping us, that matters, Your Lordship. Because there are cases when we give the approval and
take a circumstance helping the law.
I'll give the straightaway answer, Your Lordship. If it's really helping us, then we'll support him. As a public prosecutor, it is our duty to support and find out the real culprit, Your Lordship.
For getting the bail.
Your Lordship, there is a provision for that. I wait for your order if I are overstepping, but there is a provision for that. If he is already not on a bail, the bail can be granted, Your Lordship. I can give you the provision, Your Lordship, if you allow me. If the approval is already not on a bail cannot be granted, and this particular provision is there because we have to protect that particular approval, not just from the outsider or threat, but also from the other co-accused, Your Lordship. I'll give you the provision if you allow me 2 minutes, Your Lordship. In my moot court submissions, Your Lordship, in my memorial, the particular section is already mentioned. I will just give you the page number. So it is clearly mentioned, Your Lordship. So I should kindly refer the page number 30 of my memorial. On that, Your Lordship, there is a section 343. Under that, subsection 3B, shall, unless he is already on bail, be retained in custody until the termination of the trial, Your Lordship. Because he becomes a prosecution witness, Your Lordship. PW or any name he will get, and he will be a prosecution witness. To protect the witness, he should be under the custody, Your Lordship.
Which section is
Your Lordship, section 343 is the main section, subsection 3. Under that, Your Lordship, my apology. Section 343, subsection 4, under that B. So, on the very same page, I will read out the lines. I think it's about the 5th point, Your Lordship, on the same page. So, there is some clear provision, shall, unless he is already on bail. If bail is not granted to that particular approval, then it should be in the custody, Your Lordship. That is the case. Then he cannot go for the bail because of his own safety, Your Lordship. Because other co-accused, those who are at large. This is what we wanted to know. Yes, Your Lordship. Much obliged, Your Lordship.
Thank you, team,
Much
for
obliged.
your argument. With the permission of the bench, if you would like to call up the next team. Next teams are Team K and Team S. Team K will be on the petitioner side and Team S will be on the respondent.
Good afternoon to the Honorable Bench. The Counsel with permission approaches the bench of the Lordship. The Counsel is appearing before the Honorable Court in the case of Rajesh Sharma versus NIA. Speaker number 1 will deal with issue number 1 and 2, and the co-counsel will deal with issue number 3 and 4. The Counsel seeks permission to proceed with the argument. Your Lordship, the first point which indicates in this case is that sufficient evidence to prove the petitioner's involvement, the conspiracy and murder of the customer. As per NIA call recalls, internet protocols, testimonies, doesn't signify that my client, Prakash Kumar, that had crime in this specific case. There is no specific evidence to prove in the court of law that Rajesh Sharma has committed the crime. The prosecution preliminary relies on calls, records, IP logs and witnesses' testimonies to establish the petitioner's involvement in the conspiracy. However, the species of advice failed to meet the legal standard of the proving guilt beyond a reasonable doubt. It has been held in the case, which I like to indicate over here, is Sharat Virchand Sardar for the state of Maharashtra, that circumstantial evidence must consistently establish the guilt of accused in the present case. In the record only indicate communication but does not prove criminal intent. Furthermore, the prosecution has not present any forensic or documentary evidence linking the petitioner to actual execution of the crime. Therefore, there is no specific evidence to prove that Sharma was aware of the activity involved in the murder plot. The IP logs upon the prosecution only indicates internet activity and does not establish any participation of allied crime. Additionally, witnesses' testimonies have been inconsistent and lack subjective corroboration, which indicates to me, for the second point over here, the petitioner Rajesh Sharma has voluntarily expressed willingness to turn approver under section 272 of BNSS, which provides for a person accused of offence to be granted pardon if he had truthful disclosure to the circumstances surrounding the crime. The petitioner's role in this case has been largely based on circumstantial evidence, and the testimonies as an approver can be crucial for the investigation. Second case I like to highlight over here, which indicates that State Delhi Administration versus Jagat Singh. The Supreme Court held that the approver testimony is significant in establishing the truth nature of the crime, especially in the case involving multiple accused individuals. The petitioner's willingness to disclose essential information about the conspiracy, making this application legal tenable. In the present case, Sharma was illegally involved in arranging a meeting where the deceased Prakash Kumar was handed over to co-conspirator. However, there is no direct evidence linking Sharma to the execution of the crime. By turning approver, SHRI can assist the prosecution in establishing the change of event and actual role of the crime. The Supreme Court in CM SHRI was the state of Andhra Pradesh observed that any approver must demonstrate a genuine willingness to cooperate and provide full disclosure. The co-counsel will deal with issue number 3 and 4.
Counsel seek permission to address with the issue number 3 and 4. Issue number 3. Whether the rejection of bail to the petitioner violates his fundamental rights under Article 21 of the Indian Constitution. So, as per Article 21 of Indian Constitution guarantees the fundamental right to life and personal liberty, the Supreme Court has repeatedly held that the bail is a rule and jail is exception, particularly when accused is not proven guilty beyond the reasonable doubt. The continued detention of the petitioner, despite the absence of direct and sufficient evidence, violates the Article 21 of the Indian Constitution. In case of Kalyan Chandra Sarkar versus Rajesh Ranjan, the Supreme Court emphasized that personal liberty is a crucial aspect of Article 21 and that the pre-trial detention must be punitive in nature. The prosecution failure to establish strong and direct evidence against the petitioner makes this prolonged incarceration unjustified. In case of Anish Kumar versus State of Bihar, where the court ruled that the arrest should be mechanical and bail should be granted unless there is substantial reason to keep the accused in the custody, the petitioner in the present case is a noted practice and has no criminal antecedents and cooperated fully with the investigation. In case of State of Rajasthan versus Bhalchan, the court held that unless there are compelling circumstances, bail should be granted to avoid unnecessary hardship to the accused. The rejection of the bail in case, despite weak evidence and the petitioner cooperation, amounts to the denial of his fundamental
to be addressed as your lordship. May it please Honorable Court, this is Counsel number 1, Gloria Gerard Moraes, on behalf of the Respondent, National Investigation Agency, NIA, in bail application. If the Lordship had gone through the statement of facts on page 7. Your Lordship, may I please go with the statement of issues on page 8. Much obliged. Your Lordship, then I move to the issues of the instant case. Your Lordship, Counsel number 1 will be dealing with first and second statement of issues along with explanation and arguments for the Respondent, while my co-counsel Jeevan Prabhakar Jatanan will be arguing for third and fourth statement of issues. The National Investigation Agency, NIA, as the responsible Respondent, has raised the following legal issues to justify the continued incarceration of the petitioner, Rajesh Sharma, and oppose his bail application. Whether the petitioner entitled to bail despite overwhelming circumstantial evidence. The prosecution argues that strong circumstantial evidence exists against the petitioner linking him to the alleged offences. Courts have held that in serious criminal cases, even circumstantial evidence can form the basis for denying bail if the sufficiently established guilt. Kalyan Chandra Sarkar versus Rajesh Rajan, 2005. Since the petitioner is charged under UAPA Act, Arms Act and Explosive Substances Act, bail should not be granted unless the petitioner prima facie proves their innocence. The NIA versus the National Investigation Agency versus Zahoor Ahmad Shah Watali, 2019. Arguments for the Respondent, Your Lordship. The petitioner cannot claim bail merely because there is no direct evidence, circumstances, evidence is enough to sustain charges. Bail should be denied as material evidence indicates the petitioner's involvement in the alleged offences. Issue number 2, with permission. Whether the petitioner's prolonged detention violates his fundamental rights. The petitioner may argue that prolonged detention violates Article 21 of the Constitution, right to life and liberty, and that Article and that section 482 of BNSS, Bharatiya Nagrik Suraksha Sanhita, bail should be considered. However, in the cases involving national security, terrorism or public safety courts have ruled that individual liberty is subject to reasonable restrictions. Kartar Singh vs. State of Punjab, 1994. The arguments for the respondent of 2. Your Lordship, the serious nature of charges justifies prolonged detention as per section 43D 5, subsection 5, UAPA, which imposes strict conditions for bail. Inter-terrorism related cases, the right to personal liberty is not absolute and must be weighed against the interest of national security. Prolonged detention is lawful if delay is due a complex investigation. Union of India versus K.A. Najib, 2021. Counsel 1 seeks for counsel, co-counsel.
Good afternoon, Your Lordships. I seek the permission of the Honorable Bench to address issue number 3 and the arguments thereof. Issue number 3. Whether the seriousness of the offence warrants the continued custody of the petitioner, that is Rajesh Sharma. So it is noted that in the present case involves a terror-related offence, including threats, extortion and murder with a direct connection to an organized criminal conspiracy. The crime led to the murder of Prakash Kumar, making the petitioner liable under section 302, murder of the BNS 2023. The use of explosives, 20 sticks of gelatin, though the detonator was not there, Your Lordship, but yet it just instilled fear in the minds of the billionaire Mr. Ten's family, and that's why it was planted in his house, and that's why it was a serious threat to public order as well as national security, not only the billionaire industries only. Bail should not be granted in cases where the offence has severe repercussions on public safety. To support this statement, Lord, I would love to, Your Lordship, I would like to cite the Supreme Court judgment of Kartar Singh versus State of Punjab, where it was held that in cases related to national security, courts should be cautious while granting bail as it may hamper the investigation process. I would also like to cite a second case law where the Supreme Court held in the case of National Investigation Agency versus Zahur Ahmad Shah Watali, and it ruled that bail should not be granted when there exists reasonable grounds to believe that an accused is involved in a terror-related conspiracy. Secondly, the NIA investigation has uncovered that Rajesh Sharma actively facilitated the abduction and murder of Prakash Kumar by misleading the fellow officers and handing over the victim to conspirators. Your Lordship, Rajesh Sharma is not a child. If he has been told to procure SIM cards, he would question it, but he very glibly, like childlike, he has given the SIM cards to the so-called accusers whom he says that he is not a part of. But the petitioner procured and distributed SIM cards used by key accused persons, demonstrating his direct involvement in the conspiracy. All data records, CDR, Internet Protocol IP logs, and witness testimonies establish his associations with the mastermind, Ambedkar, and other accused. And it is important to note that Mr. Rajesh Sharma has been charged under the following section, Section 61 and Section 61(2) of the BNS 2023, which deals with criminal conspiracy. The petitioner played a role in the conspiracy to execute an act of terror and murder. Secondly, Section 167 BNS 2023 calls impersonation by a public servant. The petitioner misled fellow officers and caused the wrongful detention of an individual. Section 16, 18 and 20 of the Unlawful Activity Prevention Act 1967, that is UAPA, the offence constitutes an act of terrorism under the UAPA Act, which restricts bail provisions. To support this UAPA contention of the UAPA Act, it was the judgment given in the State versus Captain Jagdeep Singh by the Supreme Court, where it was ruled that conspiracy can be inferred from circumstantial evidence and bail can be denied for prima facie exists against the accused. And my learned friend, I like to counter what he has told about UAPA. Section 15 of the Unlawful Activities Prevention Act, UAPA, defines a terrorist act as any act intended to threaten or likely to threaten the unity, integrity, security and sovereignty of India or to strike terror in the people, and includes acts like using explosives or weapons to cause death, injury and damage. Your Lordships, if you see this definition, it includes in the people. People means the citizen of India. People means the belonging resident's family. And it also includes the lives which were threatened, endangered, till the time the explosives was discovered and taken away from that place where the car was abandoned. And secondly, my lord, tampering with evidence, I have to address on the issue 4. Whether there is a likelihood that the petitioner may tamper with evidence if released on bail. The investigation has examined 2 witnesses, including police officers who were misled by the petitioner. If released, the petitioner may attempt to intimidate key witnesses, including his former colleagues, that may influence them, they may become hostile. The
present case, the prosecution has failed to present any evidence showing Sharma's involvement in act of terror. The charges against him primarily refers to the criminal conspiracy and abduction, which fall under BNS and not under the UAPA. In case of Union of India versus K. Najib, the Supreme Court ruled that the UAPA should not be used as a tool for prolonged incarceration without trial. The court emphasized the mere gravity of the charges is insufficient to justify the denial of the bail unless there is substantial evidence of the accused involvement in terrorism. The Sharma has been in custody without a strong case against him under UAPA and his continued detention is unjustified. May I proceed with the prayer? Wherefore,
the charges include 302 witnesses and electronic evidence such as all detailed records and SIM card procurement records, bail application and rejection. Sharma's bail application was rejected by the special court citing conspiracy involvement. However, the Delhi High Court demanded stronger evidence to establish Sharma's direct involvement. Sharma's willingness to turn approver. On 16 September, Sharma offered to turn approver, claiming that he was a minor player in a larger conspiracy. Insufficient of evidence against Sharma. The NIA's case primarily rests on Sharma's procurement of SIM cards and his role in setting up the meeting, but lacks conclusive evidence linking him directly to the murder of Prakash Kumar. Now I may like to proceed with the co-counsel and state the issues of the case.
Good afternoon, Your Honors. May I please with the proceedings of the case for the statement of issues. There are 4 issues that are stated. Number 1 is insufficiency of evidence against Rajesh Sharma. Whether the prosecution has failed to provide sufficient direct evidence linking Sharma to the murder conspiracy. And issue 2 is right to bail under criminal jurisprudence. Whether the denial of the bail to Sharma violates the principle that bail is the rule, bail is an exception. And third issue is Sharma's role as an approver and its legal impact. Whether Sharma's willingness to turn approver should be considered for his release or leniency. The fourth issue, failure of NIA in establishing a strong case. Whether the NIA's reliance on circumstantial evidence and lack of cogent proof undermines their charges against Sharma. Further, I'll explain about the case, then how the issues can be quantified. Lack of direct evidence linking Sharma to the crime. Okay, so the evidences which has been given is called towards procurement of the SIM cards and alleged meeting to assert Sharma's involvement in the conspiracy.
So however, these elements in themselves do not constitute active participation in a criminal conspiracy, Your Honor. According to Section 120B of the BNSS 2023, there is no direct evidence between Sharma and the murderers. As per the landmark judgment in Sharad Petitioner versus State of Maharashtra, there is no circumstantial evidence must be fully established and of a conclusive nature to convict the accused. There are multiple of evidences that have been given. I'll give the case laws regarding the same that shows that the evidences are not firm and does not apply that why the client should get a bail. Okay, so Balwant Rai versus State of Punjab 1995. Can mere association with the conspirators lead to conviction? This clearly states that court rule that mere association is not enough. Active participation in the crime must be proven. So this counter the discussions with the main accused. Other case law is Devendra Pal Singh Kulhar versus State of NCT. This case is regarding the evidence is weak. Conviction will be based only on a weak circumstantial evidence. This circumstantial evidence which we have shown clearly not states that my client should not get the bail. This clearly states the court held that weak circumstantial evidence and an uncorroborated confession are insufficient for the case. The other is regarding the testimonies which have been presented. My co-counsel has stated that there are 302 testimonies. So testimonies, we cannot rely completely on that. How much weight can be given to the witness testimonies in a conspiracy? The court ruled that inconsistent with the statements weaken a case and cannot be sole basis for the conviction. That's why this case has been shown that the various testimonies are there. But we cannot solely depend upon the testimonies and we cannot hold the bail of my client. The prosecution witness Ranjit Singh Brahmajit Singh Sharma versus State of Maharashtra. Whether bail should be denied solely based on the severity of the allegations. If we consider the severity of the allegation, on this basis also we cannot violate the fundamental rights of my client. Supreme Court ruled that bail must be considered based on the merits of the evidence, which here the evidence are not very firm and we cannot solely rely on that. And there is indirect participation, just over the call or hearing something or the call records, all of these does not constitute that we should hold the bail of my client. State versus Nalini, to what extent can indirect participation in a conspiracy be held guilty? Just indirect participation cannot be constituted that my client is guilty and will be held at the bail unless and until the judgment has been shown. The Supreme Court ruled that minor roles in a conspiracy do not automatically make an accused guilty unless their actions contributed significantly to the crime. There is no proof and there is no direct evidence that my client is directly related to the conspiracy which has been held. Level of proof for conviction, the state of Karnataka versus Selvi Jayalalitha. This case law clearly states that what level of proof is required to convict multiple accused in a conspiracy. The court ruled that each accused person's guilt must be proven separately with specific evidence, not just association with others. This case deals with multiple of conspiracies, murders, intimidation, extortion. There are multiple of things and multiple of judgments can be given. So without providing any firm evidence, we cannot directly say that my client is guilty. Just by showing the call recorder, just by showing the minor which is not directly related to the thing. Which is the indirect participation and which is not directly related. May I proceed with the prayer, sir? Therefore, in the light of the issues raised, arguments advanced, and authority cited, may this honorable court be pleased to that bail appeal must be allowed. That my client should be given his judgment according to the fundamental right. He should be allowed to the bail appeal. Thank you so much.
Clearly, that Wadala record is not reliable. Why not reliable?
There are multiple calls on the number. There can be multiple SIM cards, but it did not indicate any recording for the same. The call records are there, but the call records as per the details are there, but there isn't a specific recording which can be as evidence and direct proof to this case.
You said, your second speaker said, no, you only said that approver testimony is crucial. And who would decide that? Approver's testimony would be crucial to prove the case. That is what is your case. Who would decide that?
As the in charge of the inspector, he was the in charge of the inspector. And in this specific case, he was the one who took the initiative to cooperate, and but unfortunately was not having any specific evidence. On that basis, he has been the approver in this case.
The second speaker said that there is no linking to connect the accused to UAPA. How do you say that? There is no connecting link. That is what is argued.
Your Lordship, the invocation of UAPA is legally unsustainable as there is no proof of terrorist intent or direct involvement in terrorist attack, and mere procurement of SIM card does not meet legal threshold under section 16, 18 and 20 of UAPA. So, in essence, and there is no any weapons or explosive or direct involvement in planning to attack have been linked to the petitioner.
You have not addressed the issue of approval.
Because basically, Your Lordship, this gentleman has criminal accidents. He has been dismissed from police force, and in spite after that he was reinstated. He has committed this act. How can we trust such a person? The stability of such a person. Forget his statements. How can we trust the stability of such a person? Because he facilitated the death of though the Prakash Kumar Mahamani innocent person, we do not to what extent, we can't cover the death, but what to extent he was involved, to what extent he was informed about his conspiracy. We wouldn't know. So we can't trust the words. Now suddenly he wants to become a good person, he wants to become an approver. Basically he wants to save his kid, nothing more. And secondly, sir, Your Lordship, I'd like to rebut on what my gun counsel said, that there is no evidence, there is a host of evidences. The persons were present there when Mr. Arvind Sharma, the mastermind, and even Rajesh Sharma is also a co-mastermind in that, when they planned out this conspiracy and murder. And sir, what I approached the bench to recite a prayer. In light of the above arguments, it is respectfully prayed that this honorable court reject the bail application of the petitioner in the interest of justice and national security, ensure the protection of interests and the integrity of the investigation, pass any other order as deemed fit by this honorable court. And for this,
Okay. See, till Q, both of us got confusion about the sections for the bail and the approval. Because both of us got confusion because the sections which we referred to, we got confusion. So we are not on the same line. Can you tell me both the sections for the approval and for the bail application?
Section 272 of BNSS for approval.
Please, be loud.
Section 272 of BNSS for approval, and Section 483 of BNSS to grant bail to the applicant.
For approval?
272.
Okay, But I'll ask them first. You just listen what you have to do it. You said that in your argument you said that there is no evidence against you. Is there no evidence against you? You argue that there is no evidence against you.
There are many call records, but there is no specific evidence of CCTV footage or any forensic evidence included in this case. So that's the reason I argue about the same topic. As your Lordship already questioned by Delhi High Court about the significance evidence indicates the case against the petitioner is weak, which that's the reason I argued on the same. I argued on the topic where the questioning of is mentioned in Delhi High Court about the sufficiency of evidence indicates that the case against the petitioner is weak, which does not indicate any strong evidence, any CCTV footage or any documentary or any
Okay. We got it clear. You said that no evidence is no strong evidence.
Yes.
Yes, you are able to.
Sir, I learned counsel has not studied the facts of the case. Rajesh Sharma was the facilitator of the meeting between him and the persons who killed him. He has called, there's a call data record, that is called a call data record. He has called Prakash Sharma. Maybe not on which is procured for the crime. That was basically done. So the procurement of cards was basically done on another names just because, or we say benami names, because the crime can't be pointed out to this person. But my learned counsel is when the murder section was 302 was put on him, he was charged on that based on the accusation of the wife of Prakash Kumar, who was told by Prakash Kumar that I received a call and I'm going and meeting them the evening he left on 18 July. Actually, as a husband, you will inform your wife that where you're going. I have received a call from Mr. Rajesh Sharma. I'm going to Mumbai. And there are many other witnesses, my lord. Many other witnesses. I have 5 witnesses out here. What I had witnessed.
Okay. I request to camera to be on us for some time. There are from the call everybody. See, Sonkar sir, very Sonkar sir, it strikes me that we are not concentrating very well on this for entire session, and we are not also reading this memorability how put it. Is that so?
No, it's not so.
You can't page number 15 of the the first witness. See, sir and myself got confused about alibi. We have heard this word for the first time. So, can you, everybody heard this word for the first time. Can you explain it? What's alibi?
The word alibi means
loudly, everybody.
The word alibi means that when a crime was being committed, when a crime is being committed, I as an accused, in this case a petitioner, he has to prove that he is in another place at that time, and he has to have a witness to prove his alibi. That's the meaning of alibi in legal.
Give an example.
In this example itself, Rajesh Sharma had actually claimed, but which was proved to be false, that he was in some other place during the time when he facilitated a meeting between Prakash Kumar and the killers, the co-conspirators in this murder and conspiracy.
Camera. So, gentlemen, we knew the meaning of error, right? Yeah.
No, you are asking. You just asked me.
Just we are asking. Otherwise, what you do that we are not aware of the meaning of error, right?
I understand.
Thank you so much.
Thank you, Your Worship. Thank you all the teams for your participation, your arguments, and your enthusiasm. I'd like to call my
to bring before the notice of the Honorable Court the conduct and the type of or the categorically the sort of person the appellant is. He is a suspended police person. So this is the primary factor which would apply in this case, which should be kept as a key factor to be kept in mind before I go with the charges which are imposed upon the appellant. Your Honor, so as Your Honor is already aware of the facts, may I state, come to the points of argument. Your Honor, the appellant or the petitioner is charged with sections 61, 61(2), 103, 140, 308, 314, 336, subsection 2, 351 of BNS, and more importantly, sections 16, 18, and 20 of UAPA. So, Your Honor, if it would have been a case of a person who was not holding a certain status in the law and order position, he is a suspended. It's an established fact that he is a suspended police officer. So my complete argument is based on this primary fact that he is a suspended police officer and he is well aware of the procedures and maybe the loopholes or from where he can extract a window to tap the loopholes which are there, or if there are lacuna would not be the right word, but the abuse of procedure of law can be tactfully be abused by him to tamper with the evidence, and that is very clear that he has moved an application to become an approver. So this in itself is bringing before the trial court his conduct. He has been impersonating while the commission of the crime. There is a charge of impersonation also on the appellant, the petitioner, who has come before this court for challenging the bail application, which was rightly rejected by the subordinate court. So here the contention is, Your Honor, he has already shown his conduct by impersonating as a police officer and still holding that authority. So he is under a fiduciary relation, and the person whom he might influence would not be aware of his present status of his designation which he was holding in the past. So he still has certain fiduciary control over certain departments or certain procedures which he can very well manipulate and misuse once he is enlarged on bail. Since he is a senior police officer, he knows the whereabouts and the thinking. It is a criminal mind coupled with certain powers and certain proficiencies which he has through the particular profession he is into. So that is coupled with the criminal mind. So such people are really dangerous for the society, and as the sections are rightly invoked in the subordinate code, Your Honor, which is section 16, 18 and 20 of the UAPA Act. So, Your Honor, my submission is that the petitioner cannot be granted bail on this ground. There is a established case law for this, which is NIA versus Zahur Ahmed Shah. So, as per this also, Your Honor, it is under certain UAPA acts and crimes related to that, a person cannot be granted bail under these circumstances. If Your Honor may peruse this case law which I have just
cancel conviction. Now, what can be cancel conviction? That means that your client must have been already convicted. Correct? Is he convicted or is he under trial?
He is not yet convicted.
So that means that you made a wrong provision, right?
Yes.
So what should be the correct provision?
The Honorable High Court of Delhi has jurisdiction under Section 415 and Section 528 of the BNS, which grants the High Court the authority to hear the appeals in the criminal matter. Additionally, under Section 21 of the National Investigations in 2000, the High Court has the jurisdiction over orders passed by the Special NIA Court, including bail decisions. Given that this is an appeal against the denial of the bail, this Honorable Court is well within jurisdiction to adjudicate the matter.
Your Honor, exactly my point. The application given under 415 is, Your Honor, any person, the 415 says any person convicted on a trial held by the High Court. So there are two ingredients, Your Honor. One is the person is convicted already and the trial held by the High Court. And in its extraordinary original criminal jurisdiction. So here it is an appellate jurisdiction. It's a original criminal jurisdiction which the present case is not, Your Honor, and which may be appealed to the Supreme Court. This particular section says that the appeal lies to the Supreme Court. So we are before this honorable bench as an appellate from the Your Honor, a subordinate special court. So this section does not apply here, Your Honor. And 528 is saving of inherent powers of the High Court, Your Honor. Nothing in this Sanhita shall be deemed to limit or affect the inherent powers of High Court to make such orders as may be necessary to give effect to an order under this Sanhita or to prevent abuse of process of any court or otherwise to secure the ends of justice, Your Honor. So none of the things presently have happened in this particular case.
One question to you that who is accused number one? Accused number one in this crime? Accused number 1, 2, 3, 4, 5.
Accused number 1 is Rajesh Sharma. Then it is Arvind Mehra.
Okay. When he was arrested?
He was arrested on 5th of August.
Okay. As on today, how many days he is in jail?
Much apologies, I think.
For you, question. You opposing the bail, right? Yes. The only ground for you detained in custody is based on impersonation. It is one of the impersonation. What is the other ground? One of the sections which other ground. I'm not asking this question. The only section you are stressing on is about impersonation as a police officer. Yes. That is one of the major grounds, and it is the sections of the UAPA Act which are the atrocity or the heinousness of the sections under which he has been charged, and there are certain evidences to that effect. That is the only ground we are stressing on. Yes, sir. You have all the circumstances and evidence in your only the circumstances and evidences you have. Yes, sir. And which are sufficient for you to be detained, Your Honor, because they are prima facie. The court, as the subordinate court, has also held it that the
See, they have made application under section 415 and 528 of the BNSS Act.
Your Honor, please allow me to finish. Beg your pardon. The same section was 580.
Wait. Now you tell me, you have made application under 415 and 428, 528, right? Now read 415.
Under section 415 and 528 of DLS grants the High Court the power.
We are not being supplied with this.
See, they have made application under section 415 and 528 of the BNSS Act.
Your Honor, please allow me to finish. Beg your pardon. The same section was 580.
Wait. Now you tell me, you have made application under 415 and 428, 528, right? Now read 415.
Under section 415 and 528 of DLS grants the High Court the power.
A sincere thank you to the judges, our esteemed panel of judges who have given their time, and expertise to evaluate the case performances. Who have given their time and expertise to evaluate today's performances, your guidance and insight have added immense value to this competition, and we are truly grateful. The decision of the judges. Am I audible? No. Sound.
मधून बोलो मला क्लिप घेऊ द्या थोड़े पार्टिसिपेट हाँ से करता थैंक यू हाँ सर येस थँक यू नेक्स्ट ग्रुप चला या लवकर चला इकडचे सरकार
एकदम आपल्या कंट्रोलमध्ये तुम्हाला लागेल चॅम्पियनची थोडं फास्ट लॉ स्टुडंट्स
the entry of the chief guest of the day, Justice Jadhav sir. Please welcome.
धन्यवाद
Sir, you may please take your seat. Moot court competition. As a student, actually, I never missed any moot court competitions. I always participated, so it was actually taking me back to my college days. It was good. Now, fortunately or unfortunately, we have to eliminate certain team, and only one team can win and another can be runner-up. In that context, actually, we had to judge the team. That doesn't mean that somebody is bad and somebody is good. And performance judging criteria was given. So accordingly, we had to do our job, so we had done. So don't get disappointed if some team could not qualify. And don't get overjoyed also if some teams got qualified.
So with that actually precursor, we announce, because I don't want to get along further. Of course, I have reasonable justification written for why we have chosen this kind of thing. But we have selected 4 groups for the semi-final round. That is Team A, Team B, Team R, and Team J. All the best for your next final rounds of competition. We have our judge to decide. So this will be now real court, not a moot court.
Now the round 1, it will be Team A will be appearing for the respondent, Team B will be appearing for the petitioner, Team R will be appearing for the respondent, Team J will be appearing for the petitioner. So when the competition is going on, the other team who are going to participate in this particular competition has to stay out. And two teams who is going to contest on the next time has to stay outside. Is that smart? First team will be the first round will be first competition will be among A and B. A will be for the respondent, B will be for the petitioner. So Team R and Team J will stay outside. With the faculty. R and J along with the faculty, respective faculty. We will make the arrangement. R and J. Go to the library.
Okay, may I have your attention, please? Let us have Team B. Team B, please raise your hands. Okay, Team B will be for the petitioner in the semi-final round, and Team A, where is Team A? Okay, yours will be for the respondents. Okay, so the respondents are on my right. So may I request Team A to come on my right, and Team B can take the positions on the left. Okay. Please settle down. Do I have chairs to sit over there? Just make some arrangement at least for the other two to sit. Just stand. We have some chairs here behind. Those two chairs त्यांना द्या तिकडे बसायला. Give them 2 chairs. ह्या काय chairs? या 2 chairs द्या त्यांना बसायला. The main speaker will stand and speak, the rest will sit. Okay, may I have your attention? There behind, excuse me. Now we want 3 of silence when this begins. Excuse me, ma'am. It's not allowed in my court. You have to be silent, otherwise you will be thrown out. If you want to chat, talk outside. Let them concentrate. This is an important event in the life of these students who are competing with each other. Please cooperate. And I am very strict, let me tell you, the way I am in my court. I am no different over here also. Nobody will chat, talk. If you want to chat, talk, look at your mobile phones, out. Straight away. We want to give them the best opportunity to compete with each other. Okay? Now, those who are standing with you will sit down. Please sit down. You have chairs? Okay. The lead speaker will just stand. Whoever wants to open the arguments. You also can sit down, gentlemen. आप भी बैठ जाइए. ये सब नहीं जरूरत है. Okay. Now all of you know the rules. You all will get 20 minutes each. 20 minutes for this team to submit their submissions on behalf of the petitioner. 20 minutes for this team to submit their response to them. After the 20 minutes, if required, I will decide whether I require a rejoinder from your or not otherwise. Okay? The reason is very simple. After you all compete with each other, we have another 2 teams competing with each other. So after you all finish, you all will have to walk out. You all can't stay over here. Please remember that. Okay? Along with the faculty members, all of them will be walking out. And there's a classroom arranged next door somewhere where you all can just relax. Right? Now, how many speakers are there from each team? Only one speaker? 2 speakers. Very good. So remember your time frame, 10 minutes each, or 12 and 8, whatever you all want to. Okay? Right? Now, all that I know about you all is team B is on my left, the petitioners, right? And team A are for the respondents. The moot proposition which I have been given is this moot proposition relating to indictment under sections 61 onwards of the Bharatiya Nyaya Sanhita. Is that correct? Who's keeping the time? So you have to ensure that 20 minutes are. Let them sit down, let them get up, let them ask. In the 20 minutes, whoever wants to come, they can come. Just keep the track of 20 minutes and warn them 2 minutes before time so that they know that 20 minutes are coming for you. Okay? Okay, when one team is speaking, the other team and all other members will be squatting and sitting down on their chairs. Okay? Let me tell you one more thing. We are not over here to have an elevated elocution debate competition. I am a very strict votary of this. I make it very clear. Remember that. This is not an elocution competition. Just assume, if you are educated in a convent school or an English medium school, or if you speak English in your house as your mother tongue, I'm sure you are bound to do well though. So what I will be testing you all is your mind and your vocabulary, your intellect of how you try and present yourself, the research that you may have done up till now. Because by now, I think throughout the day you all must have learned everything by heart, right? And I have just opened the brief in front of me. Okay? We'll begin the competition with this. Because we probably have another round and then the finals, so it's going to take some time. Okay, without wasting time, we'll begin the competition. And one request to the audience: if you all don't follow something, if you all don't understand something, if you want to get distracted, the door is over there. Please don't chat with each other. It's demotivating to everyone. Okay? And who knows, tomorrow you all will be in their shoes and probably they all will be sitting over here where I am sitting. So that should be the goal of each one of you all sitting over there. Okay, right, we begin the competition.
Well, Lordship permits, will start with the date.
Yes, please go ahead.
Lordship, on 15 July 2024, a Mahindra SUV was found abandoned near billionaire's house. His name was Ramesh Kumar Mansion in South Delhi. Inside the car there were 20 explosive genitals and a threat note warning Kapoor and his family of danger in certain demands as an extortion. Secondly, at the first, the Delhi police started the investigation. Then after, due to the high-profile case, it was handed over to the ATS, Anti-Terrorist Squad. Then after, the National Investigation Agency took over the case. Here, Prakash Kumar, who owned the car, refused to admit the role in the crime on July 18, as in 2024. Kumar suddenly went missing. Then after July 21st, his body found in a river, Gurgaon. He had been kidnapped and murdered. Then after my lordship, on 5th August, NIA arrested Rajesh Sharma, a former police officer, and 4 other people. 9 more arrested were made an investigation under cover of bigger Trajma criminal network led by Mehra. The NIA filed a charge sheet listing 302 witnesses, including some of Sharma's former colleagues who were misled into this crime. Sharma applied for bail, but the court rejected it. Then after, however, the court has asked the NIA to bring more stronger evidence directly linking Sharma to Prakash Kumar's murder. On 16 September 2024, Sharma filed another bail plea and about to become an approval. My lordship, the Delhi High Court asked the NIA, why didn't you give a strong evidence? Here, directly linking the Sharma to Kumar's murder. The trial is still going on, and here we proceed with the issue number 1 and issue number 2. Lordship, in case of Rajesh Sharma versus NIA, Counsel will be representing Mr. Rajesh Sharma and will be covering issue number 1, 2, and my co-counsel will be covering issue number 3. Issue number 1. Whether the evidence presented by the NIA is sufficient to establish the guilt of Mr. Rajesh Sharma. Lordship, the evidence presented by the NIA is insufficient to establish the guilt of beyond reasonable doubt. The entire case, Mr. Rajesh Sharma, based on circumstantial evidence and assumption. Here the prosecution has not presented any direct proof, any primary evidence to the Rajesh Sharma was involved in a conspiracy to murder this Prakash Kumar.
What is the circumstantial evidence which is presented by the prosecution?
Lordship, it is about a situational evidence which has not been presented. The only evidence which has been presented are call records.
Then what is the judgment of the Supreme Court which will determine CDRs?
Yes.
Which is that judgment?
Apologies, my lordship, I am not aware about that.
That's good. That's a good answer. When you are not aware, you have to say, I don't know. Very good. You can proceed with the submissions. And I will give you the judgment at the end of your submissions.
Indeed, my lordship. The prosecution relies on the fact that Mr. Rajesh Sharma procured SIM cards. Secondly, arranged a meeting. However, in this case, buying SIM card does not prove any criminal intent. The motive is necessary, the criminal mens rea is necessary. The NIA has not shown any of those direct evidence. He knew that the real purpose behind the meeting or how the SIM cards would be procured. He was not knowing that element.
See, one of the elements in this case is the going missing of a person who has been subsequently found dead.
Yes.
Is that not a very strong circumstance?
Yes, my lordship, but it is not.
It's not merely resting its case there.
Yes.
His car has also been found to have been used in the crime in question. Is that not a strong circumstance?
It is, my lordship.
It is.
It is, but my lordship, it is not linking the Rajesh Sharma from the crime or from his missing.
What is the role of Rajesh Sharma?
Rajesh Sharma, as per the known fact, Rajesh Sharma was a suspended police officer. Secondly, he has been targeted just because he was procured the SIM card, and hence, as per the Rajesh Sharma statement, he was not aware anything about the crime, and he was just been targeted. And secondly, even in case I got to cite Suresh versus State of Haryana, which is on page number 12, my lordship, 4th paragraph. The compendium is will proceed. The Supreme Court in this case clearly states that it is based on circumstantial evidence. Each fact must form a complete and unbroken chain, which is not here in the leading to the accused guilt. However, in this case, the prosecution has failed to establish a chain in our case.
So where is the chain snapping in the present case? What was the role of Rajesh Sharma?
The prosecution is just relying on the CDRs, and just on the CDRs and just on the digital evidence, they are pulling these Rajesh Sharma to the crime.
Was Rajesh Sharma not found present in the vehicle when it was parked with the gelatin sticks?
No, my lordship.
Why not?
He was not present in that.
Who parked the vehicle then?
It is unknown in this fact sheet, my lordship.
That means there is lack of investigation.
Yes.
So, are the transcripts of the CDR produced?
It has been produced by the prosecution.
What do they say?
It says that it connects Rajesh Sharma to the crime.
Then you are accepting?
No, my lordship, but just on the basis of the call records, yes, even if we pursue that.
The Supreme Court says that if there are CDR by on their own, Tufan Singh was the state of Tamil Nadu. It's the celebrated case. It says that on the basis of the CDR per se, one cannot say that there is a nexus. But if the transcripts of the CDRs are there, if the transcripts show a substantive link, is it not a strong circumstance?
Even though it is a strong circumstantial evidence, but it is not certified by 63 subclause 4 certificate, which we think it is fabricated evidence. So we request the court to not rely on that evidence.
The CDRs come from a government agency, accredited agency. They don't come from a private player.
Lordship, it is a secondary evidence, and under BSA, it needs a certificate to rely upon.
So it will be proved in accordance with law.
But they have not presented that yet.
They will present it in the trial. The trial is going on.
Yes, my lordship, but till now they have not presented, and we are requesting court to not rely on the CDR.
Suppose if the transcripts directly prove the involvement of Rajesh Sharma, what would you have to say?
The Rajesh Sharma in his statement itself has been said that he was not aware about the incident, my lordship, and even he is ready for the approval, to become an approval for the statement.
So that he can have the easy way out.
But as per the known facts, my lordship, it has been already stated the mastermind person is different, and the Rajesh Sharma was
mastermind is Arvind Mehra.
Arvind Mehra, my lordship.
And what was Rajesh Sharma's role?
As per their claim, he is a
What was the prosecution case against your client?
Conspiracy, criminal conspiracy.
How is the conspiracy hatched?
As per
whether he has a little role to play or a large role to play. If they are able to show that he had some little role to play in purchasing the SIM cards, did he purchase the SIM card and he kept it unto himself, or did he distribute them? Simple question.
Facts are silence upon that, and
no, he distributed the SIM card. You have to read the facts the way they are.
Right.
Everything will not be stated. You will have to study G.P. Singh's interpretation of statutes. The SIM cards were distributed to everybody who participated in the crime. Correct?
Yes,
that is what the prosecution case is.
Yes,
on the basis of which each one of them started having to talk with each other. The transcripts are used by them. If there is a reasonable apprehension, will they not maintain their case?
It is a high profile case, my lordship, can be
For a
fabricated.
court, there is nothing like high profile or low profile. Case is the case on the basis of the material.
It is just because of the NIA investigation, my lordship.
So what is the high
rely
profile
upon.
case? Who cares for high profile cases? We care for society. Remember that. Just proceed. I'm just trying to test you. You are doing very well, young man.
Indeed, my lordship. The prosecution mainly relies on, my lordship, further SIM card procedure, as the court knows, allegedly misleading of colleague regarding Kumar's arrest. Secondly, arranging a meeting with co-accused. But none of these factors individually altogether prove that Rajesh knew of the murder plot. Secondly, as stated in Suresh vs. State of Haryana states, every piece of circumstantial evidence must connect to each other. Conclusion, the accused guilt in this case, the facts do not point solely Rajesh involvement. Secondly, in Anand vs. NIA 2022, which is on page number 11, second last para of our written submission, it has been stated, the Bombay High Court ruled that mere allegations of a UAPA cannot replace credible evidence. Here, the same principle applies here. Without solid proof, my client cannot be held guilty, my lordship, because even circumstantial are not linking to my client. It is important to note that this case involves a billionaire industrialist and has received significant media attention. Over pressure to the NIA, ETS, all over the Delhi police. Given the pressure on these investigators agencies, it is possible that Mr. Rajesh was wrongly indicated to strengthen this case. Here, as per the established legal principle, an accused is presumed to innocent until the proven guilty.
Hence, the burden of proof lies entirely on the prosecution, my lordship. Hence, they had failed to discharge this burden satisfactorily, made it suspicious. Here, if we talk about the direct evidence, the circumstantial evidence which is not linking them. Secondly, if you come to the issue number 2, Mr. Rajesh Sharma's willingness to turn approval under section 343 of the Bharatiya Nagrik Suraksha Sanhita BNSS 2023 should be considered as a valid ground for granting him bail. Lordship, the criminal law recognizes as...
What happens to the witness statements who have testified about the role of the client?
There are 302 witnesses as being stated by...
There are certain witness statements which I find in the proposition who have testified. Apart from the CDR, the witness statement, what is the veracity of witness statements?
Lordship, the witness has been stated that I was being misled and I was called upon some place. Yes, this is testified. But Rajesh was not knowing about the incident, neither the place, neither the main motto of that meeting. This Rajesh is claiming. Even the 302 other witnesses which they are claiming, none statement has been submitted to the court, neither the defense, my lordship. So it is unreliable, my lordship. In the present case, Rajesh Sharma has submitted a formal letter in mid-September 2024 stating the willingness to turn approval. If relief is denied, my lordship, despite his cooperation to it, it has been taken that it defeats the purpose of section 343. Here, leading to this, as in case of Tariq Ambedkar versus NIA, again page number 15, last paragraph, as cited the case law. Your Lordship, the Jammu and Kashmir High Court ruled that an approver who meets the condition of full cooperation is entitled to bail even before the trial concludes. It has been stated in this judgment, my Lordship. But to protect them while ensuring their availability for trial, Rajesh Sharma has voluntarily given the statement. Secondly, to assist the prosecution, this provision has been made for the minor offenders, even though the Rajesh has been assisting the prosecution. Keeping him in jail despite his willingness would slow down the investigation and weaken the case. My Lordship, if the Rajesh Sharma has been turning to the approval, the case might be solved, the investigation can be solved as quicker as now they are investigating. Secondly, Lordship, the case involves a larger conspiracy led by the main accused Arvind Mehra, which has been going silent day by day. If Rajesh Sharma is denied relief, key evidence may remain undisclosed.
Why did your client meet the main principal accused in that case? What was it doing with? Was it discussing tea, coffee, or biscuits?
Apologies, my lordship, the facts are even the silent. But
no, the facts are there. One of the key witnesses has given a statement against Sharma, citing his meeting with the prime accused involved in committing the crime.
But
that is what is stated in the proposition.
Yes, my lordship.
You have not read your proposition properly.
But my lordship,
Mr. not silent. So what is the veracity of that statement?
Indeed, my lordship, but he was not knowing for what he is calling that person. Secondly, even he was not aware about the fact that has been happened, the incident has been happened, which clearly, undisclosed the motive of, or intentionally he has not done anything. Secondly, if Rajesh Sharma is denied relief, my lordship, if he is asking for the approval, he is giving the written application, it has been denied, my lordship. If
see, this way, every criminal will say that I want to turn an approval and I will try to come out. Is that possible in law? In criminal jurisprudence, it is very crucial to find out the role. The role is found for what? For prima facie material. Today, at this stage of bail, what is crucial is whatever prima facie material is there. We have to see the light of the day until 302 witnesses are examined. The probable 302 witnesses. So what is the prima facie material? The CDR record, the transcript, is that not substantial prima facie material to interact him and keep him behind bars?
Lordship, the facts has just mentioned 302 witness, but the statement has been not disclosed yet. The only witness which has been stated in the fact, which was and even the prosecution has not stated any 302 witness statement, which has not been covered by the
witness statements are recorded on the basis of witness statements. He is indicted. Try and understand. The bail stage, we don't have statements in law. Witness statements are there. They may have less veracity in law. But today at the prima facie stage, if they corroborate the prosecution case, can we look at them on?
Lordship, first of all, apologies for the question.
Forget the word apology. Nobody will use the word apology. Remember that. When you argue in the court of law, you never use the word apology. Don't use the word apology.
Sure,
Good one. You go on to the next proposition. You are doing well. It's very difficult to face a high court judge. Let me tell you. Especially me. So what I am in the court, I am here. I don't know if any one of you are attending my courts. Yes, next proposition.
Just last, I want to conclude my lordship to summarize. Section 432 of BNS clearly allows an accused to turn an approval. It is a profession for himself. Secondly, Rajesh Sharma's role was minor in this crime and he was not directly involved in the murder. Neither the circumstantial evidence directly links the accused to the crime. Thirdly, the courts have appealed relief for approvers who fully being cooperative in this situation. Thirdly, the court can impose condition to prevent any obstruction of justice. But here, again, the defense is claiming that even though the prosecution is claiming the 302 witness or the CDR, they have been not certified under the BSA. So, I request court to not rely upon such evidence, my lordship. If my lordship permits, the co-counsel will cover further.
Next speaker of team B.
If my lordship permits, I would like to start with issue number 3.
Yes, what is the issue number 3?
Whether the rejection of Sharma's bill by special court was justified given the available evidence and legal principles governing the bill. In the present case, the prosecution has not provided any direct evidence that appellant was involved in an offence. These allegations, even if accepted by the prosecution given, do not meet the requirement to implicate the appellant in a conspiracy. The prosecution's reliance on circumstantial evidence is insufficient in the absence of clear and unbroken chain. The case against appellant is mainly of indirect evidence such as call records or the witness statements, the statements which have been given. The court rejected the bail application based on the assumption that appellant helped with the crime. There is no forensic report or any physical evidence that connects the appellant to the crime or proves he played an active role in planning or carrying out the murder of Prakash Kumar. The case has been investigated by several agencies including the Delhi Police, ATS and NI. Despite a long investigation, the prosecution has not been able to present any solid or reliable evidence against the appellant. After the significant amount of time, prosecution only has recorded and indirect witnesses. My lordship.
Why are you reading from the paper? Come on, you can argue your case. Your colleague has argued circumstantial evidence and its veracity. Now, why should I not consider his role, considering whatever prima facie material is available on the record? And if he has not played any role, then how has the death occurred?
My lordship,
Because in paragraph 6 of your proposition, the NIA during its investigation has clearly uncovered the role played by your client, and it says he had a major role to play in the sequence of death.
My lordship, as Rajesh Sharma was not knowing what actually has happened in the incident. He set up the meeting, but he was not when the meeting was why the meeting was set up between the Prakash Kumar and the Ambedkar.
But he attended the meeting with the main conspirator. It says so. Your proposition at serial number 9, paragraph number 9 says that one of the key witnesses gave statement that against Sharma citing his beating with the prime accused. So is this not good enough prima facie material? If somebody asks you, go and purchase 15 SIM cards for me, would it not be your duty to ask him, why are you asking me to do this?
Yes,
15 SIM cards can be misused by somebody.
But my lordship, there has been not in the proposition that how much.
And your client happens to be a celebrated officer, right? Having won laurels for himself. So will he be so naive to buy 15 SIM cards and just give them away?
My lordship, I'm aware that he might have bought the SIM cards. He might have bought the SIM cards, but he has no idea.
Okay, are you aware about one fact how SIM cards are bought? When we buy a SIM card, what are the conditions that are required to be adhered to?
The documents have to be given.
What are these documents?
Aadhaar card.
Public documents, right?
Yeah.
Why are they required to be given?
The authenticity that the person is.
Now, if one person buys 15 SIM cards, I'm sure he must be giving document of 15 unknown persons, unsuspecting persons. Is that not right? Is that not a crime then, to begin with?
But my lordship, there is nothing written in proposition that Rajesh Sharma had got the 15 SIM cards. He got the SIM cards, but he had no idea that why the SIM cards were used.
Anyway, you all have finished your 20 minutes?
Yes, I would like to conclude with the prayer.
Yes, please conclude.
In the light of issue raised, arguments advanced and the authorities cited, the Counsel for Appellants humbly prays that the Honorable Court be pleaded, set aside the special courts and grant bail, considering the insufficient of evidence, and consider the appellant's willingness to turn approval under section 343 of BNSS 2023 and extend the appropriate relief or pass any order that Honorable Court may deem fit.
Okay, thank you. Yes, the respondents, NIA, you are the prosecution team?
Yes, Lord.
Yes. Okay, the other two speakers can sit down. All three will not stand. Yes.
May it please Honorable Court, I am representing the NIA to the other respondents, Your Lordship.
You are the prosecuting agency, right?
Your Lordship, if you are well-versed with the factual case, can I continue with the arguments?
Whatever way you want to continue. I don't decide how you have to continue.
Okay, Lordship. There are few things which were missed by the appellant. Hence, I have to keep those things in front of you, Your Lordship. First of all, how NIA got involved with the case. On 15 March, they found an abandoned Mahindra SUV.
That was told by.
Yes, Your Lordship. But then, Your Lordship, the thing is that the place where it was discovered was a South Delhi, Your Lordship, and that was 1 month before the celebration of Independence Day, Your Lordship. So all the agencies were highly all alert, the surveillance was going on. Along with that, Your Lordship, the transport authorities of the Delhi were very much concerned with the pollution matter, Your Lordship. So each and every vehicle who is not having the number plate of Delhi is getting monitored. Still, a vehicle having that amount of explosive were found in that particular area. So this triggered this triggered all the agencies, Your Lordship. First was investigated by the Delhi police, Your Lordship. Later on, it was found that this particular vehicle belonged to the Prakash Kumar, Your Lordship, and on 18th, his family reported that he got missing. On 21st, his dead body was recovered. Now, till that, the ATS was handing over the man. How, Your Lordship? Because the timing on which the explosive got recovered from this
What is the case against Rajesh Kumar?
Sir, Rajesh Kumar got introduced when we got the surveillance and got the CDRs, Your Lordship. Now the opponents were raising a question on CDR, but as we already aware, also the Honorable Court or a police officer can retry those particular vehicles, Your Lordship. It is not easily available, it is not public data, Your Lordship. So after analyzing that particular data, it was found that Mr. Rajesh Kumar and the DC is a victim, Your Lordship, here, Mr. Kumar, who is dead now. They were having a conversation immediately before he got missing, and even after his dead body was found, Your Lordship. So after analyzing his call takers with another numbers, Your Lordship, then we got some other numbers which are getting frequently called. So we called for the call takers of that particular numbers of the Lordship, and we found that when we traced back the numbers, we just found that the SIM card was actually procured with some KYC document which was not in the name of Rajesh Sharma, but other key witnesses, those who are selling the SIM cards and those who are making it available.
How will you indict him for his role of committing the murder of Prakash Kumar?
So two things. His family members, when they reported this missing complaint, they clearly stated that here, that because he is not accepting the guilt, something bad can happen to him. This particular fear was raised during the missing report. Secondly, Your Lordship, he was the last person who have seen him alive. Next time, Your Lordship, it is clearly, Your Lordship, when this particular vehicle got retrieved, so he was the most wanted person, Your Lordship, Mr. Kumar. So here it is given that the Mr. Rajesh Kumar, he acted as a serving officer and gave some false information to the police officers, Your Lordship, to arrest him. The police officer who arrested him, they were not aware about his true identity. Otherwise, Your Lordship, this particular Kumar is a wanted person because his car was found in the south area, Your Lordship, with the explosive. So they planned a meeting where actually Sharma went, and there he handed over this particular Kumar to other 4 individuals who planned their murder, Your Lordship. So in this conspiracy, Your Lordship, which was tracing back to the Mr. Mehra, each of the players had played some important role, and this which could have made out from the CDR, Your Lordship. If 2 people are continuously calling, Your Lordship, there has to be some motive.
If it is merely based on CDR, the story that you are telling us, telling the court, cannot be true. You have to show something which is more stronger than that.
Yes, Your Lordship. Another
Something
thing
which is more cogent and which links, because in criminal jurisprudence there is no preponderance on probability.
I agree, Your Lordship. I really understand your question. However, Your Lordship, along with CDR, there is IP laws.
Otherwise, I have to grant him bail.
I do understand your Lordship, but I humbly submit, Your Lordship, there are IP laws. IP laws can be traced back to the location, Your Lordship. CDRs cannot be located. Even CDR, Your Lordship, if you understand the content of the CDR, when call was made, from which location it was made, it's clearly available. Along with IP, we can trace back even the tower location, Your Lordship, where the Sharma, he was presented, where this incidents happened, Your Lordship, where the vehicle was retrieved. Sharma's presence was indicated because of the IP logs. When Mr. Kumar, he got missing, his IP logs was available over, Your Lordship. So based on this, Your Lordship, this is a crime, Your Lordship, but we feel that we trace the Mahindra SUV at the preparation stage, before even attempt stage, Your Lordship. Because in the 4 stages of crime, the attempt, before the preparation and the intention, Your Lordship.
Is it your case that you are directly involved in the murder?
Your Lordship, we are not stating he is directly involved. That's why we have evoked the section 61 of the conspiracy. Because, Your Lordship, he handed over.
What was his role in the conspiracy?
Your Lordship, let me just
Tell out his role in the conspiracy.
Your Lordship, in the conspiracy, this clearly mentioned that 2 or more people, they have a common object.
That is the definition.
Yes, Your Lordship.
Without his role in the conspiracy.
Your Lordship,
In a sequence.
Your Lordship, Mr. Kumar was not easily available to all the co-accused. If he was easily available, there is no need of Sharma to arrange of this meeting. Sharma, he created a scene where he had to come for the meeting, Your Lordship, and then he handed over to the person. Now, if they wanted to murder them, he was available in the Bhopal, Your Lordship. There, his whereabouts were easily available to other accused. But he was well aware that they wanted to, go for his murder or to do some harm to him. That's why he was avoiding them. But Sharma facilitated that meeting, Your Lordship. And this meeting, before that, he had a meeting in the police commissioner office, Your Lordship. So what NI is trying to case a case, Your Lordship, this particular SUV which was found in that particular area, that was without detonator. So now his intentions was to create an explosion, to create a terror. 2 things, Your Lordship, which NI found in investigation, that threat was to be direct.
So you agree that the murder took place after the vehicle was found?
Yes, Your Lordship.
Correct?
Yes, Your Lordship.
So why was he murdered?
Your Lordship, now...
The answer is very simple. The vehicle belonged to him.
Yes, Your Lordship. It was easily traceable.
What was the cover-up which Sharma wanted to do?
Your Lordship, the only thing is, he was not the only person who was involved in this particular activity. Because, Your Lordship, suppose if I am planning an activity, I'm just giving for the sake of argument, if I am planning an activity, and it was not that easy that Mahindra can be traced back to the owner, Your Lordship. They are not hiding anything. The chasing numbers were there, everything there, so it was easily traced back to. However, Lordship, we believe that Sharma took that vehicle because, Your Lordship, our businessmen for the Bhopal, having no knowledge of the Delhi police or the security arrangements, cannot drive the vehicle deep inside the South Delhi and park them with the explosive. So, Lordship, these are explosives, this particular explosive, they are not easily available, Your Lordship. They are regulated by the rules and regulations. The whole carton is available with the barcode, Your Lordship. They can easily trace back. So tracing Mahindra and this particular explosive, Your Lordship, there are 2 different things. So we believe, because he was a weak link, he can directly...
These explosives which were found, they are available to those people who are agriculture, for the farm?
Not officially, Your Lordship. I humbly submit that, not officially. There is a provision for that. There is a regulatory body. There are those who are the manufacturers, they are regulated. They have, if you have to purchase something, like gelatin, these are explosives used in industrial use. You are absolutely right, Your Lordship. However, if you want to manufacture or if you have to purchase, there has to be a license, Your Lordship. However, Your Lordship, there was a vacuum, Your Lordship, in the provisions. They sell in a carton which having a barcode, not individually. But now, after this incident, they have changed it. Now, individual gelatin candlesticks can be traced back to the owner and those who are distributor or the manufacturer. But when this incident happened, it was not possible. So, in the grey market, Your Lordship, it is available. But that, Your Lordship, 1 or 2 candlesticks, 20 candlesticks at the same time were available in the Delhi. Your Lordship, we humbly believe that if I am to give a threat to the billionaire, any day will be possible. When the whole Delhi is on high alert, every agency is looking for the threats and explosives. Why anyone will go for that? The only reason.
What according to the prosecution is the role of the applicant who is seeking bail, whether in giving threat or whether in extortion or whether
we humbly submit that, Your Lordship. The threat was intention, even terrorist activity was, but the timing, Your Lordship. The day the SUV was recovered was not the day they wanted to go for this particular attack, Your Lordship, because there was no detonator, they never wanted to explode it. Your Lordship, second thing, the threat note was found inside the vehicle, Your Lordship. There is no prudent man cannot understand how that person from whom that threat was intended can directly have access to the threat note. It was a police officer who got the threat note. It means, Your Lordship, they were planning something, and in between, because the whole agency was in high alert, they got red-handed, Your Lordship, because the vehicle was there in no parking area in the South Delhi, and that's why. So, Your Lordship, you can say that the bigger conspiracy was in place, and that's why NI got involved. NI got involved because it was a scheduled offence, Your Lordship. In terrorist activities, explosives are often used in Gujarat and any other cities. So, this gelatin bomb in a backpack is not the first incidence of this kind of offences, Your Lordship. And also we believe, Your Lordship, because these two police officers have had a meeting.
Why did they murder him?
Your Lordship, as rightly said, he was a weakling. He was not an expert. These two people, that is main prime accused, that is Mehra and this Sharma, they were well-trained police officers. Even they are aware about all the evidences, Your Lordship. So they cleverly planned this particular operation, Your Lordship. But this particular person was a businessman, and he gave his vehicle, Your Lordship. But we humbly submit that there is no chance that Bhopal person can drive his vehicle from a national highway where everything is CCTV is available, his car number will be traced automatically, and drive deep inside with the gelatin candidate. So we believe that his car got utilized, Your Lordship, but he is not linked with the explosive. That time, Your Lordship, Sharma realized that he can link him, that missing link, Your Lordship, he can connect. If investigative agency could have reached him before the Sharma, we could have traced the whole conspiracy, Your Lordship. So they eliminated a key witness, Your Lordship, prosecution witness, and Your Lordship, because of that, we are searching for the evidence. Because secondly, Your Lordship, we haven't submitted a forensic report on the
What is your objection to him running in approval?
Your Lordship, most important thing is, during the investigation, he never disclosed the facts. Now we wanted to disclose the fact when we are stating that he's a key accused, Your Lordship. We are not saying he's a crime accused, he's a key accused, and he is involved in all activities after the car got recovered, Your Lordship. So our objection, Your Lordship, this particular facility approval, this particular section is created, there is a legislative intent behind it. If there is no specific evidences available which can link all the participants of the particular crime, then those who have any person, Your Lordship, it is not related with just the accused or any person who has the knowledge of this offence can be useful as an approval, Your Lordship. However, Your Lordship, now first bail got rejected, second bail got rejected, now we have something to say. Now he is bringing something on table, Your Lordship. So, as a dismissed police officer,
why making application can be a change in circumstances, subsequent changes? He is entitled to ask for bail.
Yes, Your Lordship.
Nothing prevents him from asking.
He can ask for bail, Your Lordship. However,
I am asking you, what is your prime objection to that?
Sir, I have a prime objection regarding the bail and approval. I first come with the bail and second the approval. First, in the bail applications, now in the charge sheet is clearly mentioned the unlawful activities offences are there. So section 43B, Your Lordship. If you allow me, I'm submitting the landmark case Wadala, and there is another case, Your Lordship. In fact, in second case, Your Lordship, the CDR reports were utilized as evidence. It is the Jurisdictional Singh versus State of Punjab, Your Lordship. I kindly accept my submission.
There are cases that don't accept the CDR reports.
Your Lordship, they have accepted that CDR can be the reason for the primary suspension.
So what cases can CDR reports be accepted? Tell me that.
I beg for your pardon.
What cases can we accept CDR reports prima facie?
Your Lordship, it's a forensic evidence. When there is no prime key witness or available, eyewitnesses are available, or any other ways where other incidents are not available, we can use of technology to identify the particular.
How?
Your Lordship, let me just give you an example, a case which was solved. I think you are aware about it. A victim, he did some crime and he went to his hometown in the Madhya Pradesh, Your Lordship. So what police did is they identified how many people were active in that particular tower. So they narrowed down to the 5,000. And after that, they tried to understand how many people change their location immediately after the crime. And they realized that few people, they are tracing back and changing location back to the place where this particular accused went. So it's a technical thing, Your Lordship. However, after tracing back, they realized that they were having a frequent conversation, Your Lordship. So circumstantial evidences can be utilized like this in the forensic evidences. But there is no other material, Your Lordship. There is no eyewitness, there is no CCTV images available. There are places in the rural areas where there is absolutely no CCTV available. Even for 10 kilometers, there is no man even standing, Your Lordship. That time,
that is not the answer.
My apologies, Your Lordship.
That is not the answer. You have to tell us why should CDR not be accepted.
In this particular case, Your Lordship, CDR has to be accepted because
that is what their case is. They are insisting on that.
Your Lordship,
not adequate evidence.
Investigation is not yet completed, Your Lordship. These are the prima facie evidence which we have received. It was a big controversy, and when investigating agencies start an investigation, they always have to look for some clues. So CDR is a starting point, Your Lordship. We have already mentioned that even though charge sheet has filed, investigation is already going on, Your Lordship. When multiple people having their expertise like this business police officer, they are working together in a plan and having no background, it is very difficult for NIA to get the witnesses, Your Lordship. However, still we have to able to crack down the conspiracy and there are 302 witnesses.
You have listed 302 witnesses.
Yes, Your Lordship, we have tracked down their conspiracy.
I'm sure out of the probable 302, you will be examining at least 100 of them.
Yes, Your Lordship. So it is clearly mentioned that there are some of the key witnesses, and few witnesses have clearly stated that it is not mere depending on the CDR, Your Lordship. They had a physical meeting in the police office, Your Lordship, where both of them are dismissed. So there is no legitimate reason that these two people are meeting in a police department, Your Lordship. We suspect that, Your Lordship, all the surveillance details or many confidential details were available in this office, Your Lordship. And we have already, even the witnesses already stated that he influenced in Your Lordship as a serving officer. So he was acting as if he is already in a service, Your Lordship. So he has that kind of expertise to influence even a trained officer, Your Lordship. So imagine what influence he has on normal people, Your Lordship. So we feel that he made physically. And later on, we are supporting that particular claim with the CDR, Your Lordship. That is with a sufficient prima facie evidence, Your Lordship. And we just don't want to hurriedly complete the investigation. We haven't completed the investigation yet, and we haven't filed a closure report yet, Your Lordship. We have asked a time for the special court, Your Lordship. That's why the case is at an inquiry, Your Lordship. There is no specific charge which has been decided by the court, Your Lordship. Even the court has given the time us to investigate so that we can create a complete.
Okay. Yes. Any other speaker is there?
Yes, Your Lordship.
Yes, I will take over. Let her take over.
I am Muda number 2 for the team A. May I proceed with the issue number 3?
Yes.
Much obliged. Whether Sharma is entitled to a pardon as an approver under PNSS Act.
Correct.
Your Lordship, I humbly submit that Sharma is not entitled to a pardon as an approver under PNSS Act under section 343 and 344.
Why?
Your Lordship, because
don't you think he will help the prosecution in unearthing the real culprits of the crime?
Your Lordship, because Rajesh Sharma is a mere conspirator.
See, this is a case of epic proportion according to the prosecution, right?
Apologies, ma'am. Rajesh Sharma is a mere accomplice, but a key conspirator and executor in kidnapping and murdering Prakash Kumar, as well as the bomb scare intended for extortion. Tender of pardon is given only when evidence is insufficient to convict the primary accused. But in this case, NIA has gathered all the strong evidences like CDRs, forensic reports and witness testimonies, which sufficiently establish the guilt of Sharma and his co-accused. The purpose of pardon is to secure evidence against the main accused. By granting it, it could be undermine the integrity of judicial process. Given his active role in executing the crime, pardoning him would be against the principle of justice and deterrence. Therefore,
nobody pardoning him just now. Your investigation is under progress. Just now, all that he is seeking is merely bail. What he is saying that the material evidence which is there in the prosecution is inadequate. According to you, CDRs, witness testimonies, are they good enough in law? Why should I consider them good enough in law to keep him behind bars? See, as a lawyer, you have to think out of the box. The question is asked, right? This is not a foreign question. It is related to this only. As I told you, this is not an education competition. So you have to be ready for all the questions. So what do you think? Is CDR records and witness testimony is good enough for you to keep it behind bars? Or is it inadequate according to what they are doing?
Your Lordship, CDRs,
I have already given the answer when I was quizzing them to this question.
Yes, Lordship.
Therefore, you should pay attention. What was the answer that I gave? The answer that I gave was, if the transcripts of the CDR show his direct nexus or involvement, then that material can be considered as prima facie. Otherwise, Gopal Singh says, Gopal Singh versus State of Tamil Nadu, I think it's 2021 Supreme Court. It says, at the time of trial, near CDRs or near locations.
Your Lordship, may I begin with the prayer?
No, you continue your submissions, don't worry. This is my way of testing you all, remember that. You all have done a lot of mooting, no? Moot courts and mooting, intra-college, inter-college. I doubt whether you all have come across something like that. Anyway, you are doing well. Yes. Put your case. What is your case?
Therefore, your
You should be denied bail. You should be kept behind bars.
Yes.
How much time does the prosecution, will the prosecution take to complete the investigation? Is there any fair idea? The answer should be, we'll make every endeavor to do it as fast as possible.
Yes.
That is presence of mind. Right?
Yes, sir.
Okay, thank you very much. Done well.
Much obliged.
Both the teams have done very well. And what we can do is, we can ask you all to retire to the classroom along with your faculty and friends. And we'll call the other teams. The organizers are requested to take the teams and the faculty members to the classroom and get the other teams over here. We'll announce the final after we finish the other round. We'll call you all over here.
Teams, those who are going out, please, along with the faculties, you should move out with the faculties. May I request the volunteers to call the next to the side? Yes. May I request all the participants and the audience to maintain silence. Even if you are moving out, keep silence.
Can we get the other two teams?
Yes, sir. We have already with your permission, sir.
May I request the teams who have finished to walk out, please, so that we can have the other two teams?
Your Lordship, they have walked out and the new teams are coming.
Yes.
May I request complete silence in the courtroom?
Team J on the left, Team R on the right. Team J on the left hand side.
Team J on the left hand to the right, and Team R the right to the left. J will move to the left of the bench and R to the right.
Team J on this side, left.
With your permission, Lordship.
The teams are there?
Yes.
Okay. You all know the rules? Both teams? You all get 20 minutes each. You all can divide the time on y'all. Whoever wants to speak for as much amount of time in those 20 minutes. Okay? Take it from me that I know the facts. So make the submissions. Okay? Yes. You all can sit down. Only the speaker who is speaking will stand, the rest of them will be sitting down. Team J on the left, Team R on the right. Team J is for the petitioner seeking bail. Is that right? Or you don't know?
Yes, sir.
Yes. What bail or no? Because you look a little perplexed. And Team R is for the prosecution agency. Is that right? Yes. The speaker may begin. The time starts now.
The counsel seeks permission to address this. The counsel seeks permission to address this honorable bench to be addressed as your lordship. May it please the honorable court, this is counsel number 1 on behalf of the petitioner in the matter of Rajesh Sharma in the bail application versus National Investigation Agency Respondent. If the Lordship had gone through the Statement of Acts, page number 7 and 8.
Please argue, continue. Take it from me that I have gone through everything. Take your own time, okay? Relax.
The Statement of Issues for Petitioner, page 9.
You are going to speak on which issues?
On 1 and 2.
1 and 2.
Yes.
Okay. You can just combine 1 and 2 and give your submissions between your submissions.
Sufficiency of prosecution executed evidence for continued incarceration. The petitioner argues that the prosecution has failed to provoke enough credible evidence
to provide
enough credible evidence.
Do one thing, don't read. Keep it down. You want to be a lawyer? No problem. Just tell me like a story. Whatever you all have discussed amongst yourselves. In a court, no, you can't read like this. No? What will the judge think? You are mooting. What is mooting? It means arguing. It means a debate. Okay. Permission granted. You can read.
If the evidence is weak, the petitioner argues that the prosecution has failed to provide enough credible evidence to justify the continued detention. If the evidence is weak, consistent, or does not establish a strong case against the petitioner, the prolonged incarceration would be.
So why did you say that the evidence is weak and you should be granted bail? What are the reasons for that? Your incarceration in prison is questioned by you. You want to get out. You want to enjoy your right to liberty. Article 21. So, just now you said the evidence is weak, the prolonged incarceration is not justified. Why? I'll try and help you out. According to the proposition, your case is that prosecution case is based only on CDRs, and CDR is a weak piece of evidence. At the bail stage, the court should not go into the CDRs. Do you know what is CDR?
Yes.
Why should the court not go into the CDR at the bail stage? What is the answer to that? Why is it considered to be a weak piece of evidence? Why?
Because on that basis the court will get the evidence.
But then if the court gets the evidence, then they
But
are
I'm
going to be
asking
in
for
jail.
bail. Yes,
Then you
but
have
I'm
to be in
asking
jail.
for bail.
You are asking for bail.
Yes.
You can't argue the prosecution case, right? See, read the proposition. The proposition says CDR is a weak piece of evidence. So why is it weak? The second case of the prosecution is that they are relying on witness statements. I'll help you out. You can argue the role of your client in this crime. You can say this is the role of my client and I don't think is further incarceration is justified. Can you argue the role of your client? Can you? Yes, go ahead.
Give me some permission, I could get back to you.
Huh?
If you give me some permission, I would get back to you.
All permissions are granted in mine. If you want to read from the transcript, you can read also. Don't worry. Relax. See, this is the acid test that you will face in court. The court can ask you any question relating to the case.
thought it is exhaustive. Exhaustive.
No problem. You can shorten it. If it is exhaustive, you can just shorten it. Tell me in point form. Tell me in 4 points. What is the role of your client? Why has he been arrested by them? Tell me. What did he do?
Circumstances evidence is procuring SIM cards and confiscating or using which do not amount to conspiracy or direct involvement in law.
So he purchased 15 SIM cards for what? For a Diwali party with the genital sticks. Why did he purchase 15 SIM cards? Can a person like you and me go to a shop and purchase 15 SIM cards?
He wanted to distribute among his co-conspirators.
Correct. So you are admitting conspiracy?
That is the case of the respondent, not us.
But I can tell you one thing, madam, you will be a very good prosecutor. Today you are on the wrong side. Why should the court release your client? Argue. You can have a discussion. Help us. Please help us.
May I take over?
Yes, yes. You are welcome. No problem. No problem. Let him take over. So he gets a little longer. Take it.
May I just the section?
Go your way.
Your Lordship, I will seek permission to speak on all the statement of issues.
Yes.
The first one, I'll just take it out and then I'll speak it again.
Yes.
Whether the prosecution has presented sufficient evidence to justify the continued incarceration of the petitioner. Whether the petitioner is entitled to bail under the principles of criminal jurisprudence. Whether the petitioner's right to a fair trial and the presumption of innocence has been violated. Whether the petition offered to turn a pro under section 343 of the BNSS Act 2003 should be considered in granting bail. Your Lordship, I just state my argument. Sir, I argue that the threat note which was found in the Mahindra SUV is unanimous. It means it is addressed to Prakash Kapoor, the millionaire list. No full names and any address mentioned in the said note appear to be life-threatening, meant for the recipients and probably to their family. The entire content of the said note appear to be ambiguous and thus apparent force. Because my client, the petitioner, has been blamed to have written that note and placed it in the Mahindra SUV.
So there is no direct evidence to link your client's role in putting that note. Is this what you are arguing?
Yes.
Yes.
Based on the evidence which the NIA has provided to us, point by point I am providing that. I further argue that in recent past, the billionaire investor's family have already, and his organization, whatever companies, have received number of threats, including bomb calls, but in none of the cases the provisions under UAPA Act have been invoked. Only why only this particular?
That is because a vehicle laden with explosives has been found below his house or near his house with a specific threat note that he is the target. Therefore, UAPA has been invoked.
But Your Lordship, even bomb threats and bomb calls are not simple threats. Even a bomb threat goes to, if I call up an airline, which many cases have happened in these days, even a bomb threat goes to airline, that the entire flight is stopped.
So you arrest everybody who is innocent of things?
No. What I am saying, whatever threats are there, why the threats which have received before, why they were not invoked, why the UAPA Act was not invoked?
But then are you arguing for the prosecution or for your client? You tell me, why should the court look at your client as
I'm not arguing the prosecution. When I'm saying, when they have received bomb threats before, why didn't the NIA come? Or the previous criminals, whatever, why in those cases, the UAPA, if those cases were registered with the NIA or CBI.
That is their problem.
That is their problem.
They have your problem or their hit.
I'm not arguing with
We are concerned with our problem, your problem. You want your client out or no?
I want my client out. That's why I'm arguing. Your
Tell
Lordship,
me, why should they bring him out?
yeah. Basically, sir, I've just compared him of 4 cases.
Yes.
Wherein the charges against those 4 I would call accused were quite
serious.
Serious in nature. Like in the case of state of Maharashtra, the judgment delivered by the Supreme Court of India in the state of Maharashtra versus SHRI MILIND JADHAV, he was granted bail.
Give me the citation.
First one, 11/2/2009.
So he was granted bail.
He was granted bail.
Despite he being involved in a serious offence. Okay. What was the offence?
He was a judgment taker. One second. Sir, he was much apologies, Your Lordship. He was an accused person who was facing trial for alleged commission of offences punishable under section 13, 10, 13, 18 and 29 of the Unlawful Activities Prevention Act 1967 and section 3 of the Arms Act, which is almost similar to this case. When I applied for bail application for my the petitioner.
So why was he granted bail then?
He was granted bail because it was seen, if you see the point number 5 on page 4, it is seen that the charge sheet does not comprise the statements of witnesses as to exact involvement of the accused persons described as involvement to correspond to the ingredients of section 13, 10, 13, 18, 20 of the Act.
I understand the trial court in this case had given him bail. The state prosecution went to the High Court and got the bail cancelled. When the matter went to the Supreme Court, the Supreme Court stated that it is not possible for the High Court to cancel the bail because there was no change of circumstances. And therefore what the High Court did was wrong. Now that is not the case over here. Try and understand, when you cite a citation, it has to be akin to your case on facts.
Hearing also, Your Lordship, if I am able to refer, the circumstances will have seen when the NIAC, they have compiled the witness statements of 302 witnesses as well as evidences.
I understand.
Yeah.
They are not saying they have compiled 302 witness statements. They have recorded certain witness statements which take the name of your client.
Yeah.
Just suppose to examine 302 witnesses in the trial that they will have. Today we are at an interim stage, so we have to see whatever trial basic material they have. So CDR is one, and witness statement is the other. So why, according to you, are these too much evidences weak to enable your client to come out on bail? Why? What is the reason? Why should I consider the CDR statement as a weak evidentiary value at this stage?
Well, as such, sir, not only it can be tampered with.
No, CDR cannot be tampered with. It is already done and dusted. Final transcripts are here. Why is it a weak evidence? Why is it a weak piece of evidence? See, you can say that it is weak because it should require corroboration. Stand alone, don't look at the CDR. Stand alone, CDR may establish that I have a link and a nexus because I was talking to the person. But the answer to that would be what? the transcripts, आपने क्या बात किया उसके साथ, उसके ट्रांसक्रिप्ट अगर आ जाते हैं, and the transcripts are linking to the present crime in question. Now, what is the present crime? It is a multifaceted crime. It is related to theft, extortion, and murder.
Alleged.
You are not alleged. You are not even telling me what is your role in the murder. Who murdered that person? Prakash Kumar. The vehicle belonged to him. There is material from their side that you were instrumental in having to making with the crime accused. What do you have to say about that? All these are pointing a finger towards your indictment. Why, according to you, at a prima facie stage, should the court disregard it? Tell me that. Why? If you satisfy me, I will immediately give you bail.
And sir, as such, I can only argue on that point that the gelatin sticks which are found in the SUV vehicle are cheap explosives. Used by industry for the purposes of mining and construction work. They cannot be used without a detonator. Thus, by themselves, gelatin sticks do not lead to explosion.
So it was a hoax kind of.
It is kind of mischief hoax.
Mischief. Some miscreants playing mischief.
Playing mischief.
So even assuming that your client has played a role, it should not be so serious. It should not be considered as so serious.
Yes.
And it should be given his liberty. That's a good point that you made. Anything else?
And secondly, Your Lordship,
right to life, right to liberty. You don't want to argue on that. He is in jail. He is not seeing the sun, the moon.
the article 21, right to life and liberty. In his case, we have based on Your Lordship, our statement of jurisdiction in this particular case for the petitioner is based on the articles 226 and 227 of the Constitution of India, read with section 480, 483 and 528 of the Bharatiya Nagrik Suraksha Sanhita 2023. So, and as per the article 21 of the Constitution of India, the right to life is there. But basically, what we are asking, he be granted bail, but he be granted bail under certain conditions.
So you are saying stringent conditions, but don't answer the liberty.
I just said he does want to receive the sun, rain, wind, everything. So let him be given the bail to section as per the section 480.
What is your case on he coming an approval on that? You have only 2 minutes.
He becoming an approval, sir. He becoming an approval, but basically that was filed with the petition basically to get a relief. Basically, if the indictment comes in, so he can get some relief.
Accept your case that he is coming an approval. I will be released from bail then. The bail can be granted. Why should I?
Sir, basically because he was involved in illegal activities before as alleged. So basically, if the investigation has to go on, he should be not in such conditions where his mental setup is as such, he can't give a proper statement or he can't divulge the facts or if his life is threatened. Because if he's going to divulge the facts about whether he was forced to do this work or whether the mastermind, forced him to do this work, then he has to be in such a condition where he's protected.
I just hope and we don't follow this principle for all this.
Not for all. But anyway, we are asking for him to be released under section 480 on certain stringent conditions.
Despite his involvement
and he has been away from his family for a long time.
Okay, thank you. Thank you. It's not easy to face the barrage of questions that the court asks.
Because of your humility.
No, I think both of you all are illustrated very well.
Basically because of your humility.
Yes, come on, the respondents, you can respond.
Counsel seeks the permission.
Yes, permission is granted, all permission is granted.
Yeah. Much obliged, Your Honor. 14 July 2024. There was an incident. One car, SUV, was stopped at one of the villages, Mr. Ramesh Sharma. Mr. Ramesh Kapoor.
Sharma Kapoor.
Mr. Rajesh Sharma, the police officer who was the prime accused, was involved in the case. We, the National Investigating Agency, wants to plead before the Honorable High Court of Delhi to cancel the bail application given by the Mr. Rajesh Sharma. And Rajesh Sharma is the prime accused in the said case, as his has the SIM card which was used for the all communications done when the incident was happening. NIA took up the case on their hand. From then they have believed, and to that extent, that the Rajesh Sharma, the police officer, has been doing such kind of historical evidences that he was having such kind of cases on him. So he must have to be in a jail in order to make and to prove the national security to be there.
Why? He can even be granted bail and he will cooperate with the investigation. Don't you think so?
The prime accused, Mr. Rajesh Sharma, has the history of getting bail again and again, but he is again and again doing the crime. And because of considering all the facts that if we grant the bail, the same precedent will be followed thereafter. So I humbly request.
But suppose if he anticipates the search and if he reoffends himself, we can again put him back in jail. What is the condition under the CRPC, which another Sanhita now, where we can ask him to be arrested again? Under the provision.
Under section 439 of Bharatiya Nagrik Suraksha Sanhita.
Bracket 2.
Yeah. Yes, Your Honor.
We can bring him back. So what is wrong? We can give him bail. His right to liberty is affected.
He is a prime accused in a given
crime accused. So what are the reasons why we should keep him in bail and not grant him bail?
We should not grant him bail because
let him incarcerate further.
Because we want to further investigate the matter in order to go deeper and in order to find the further mastermind behind the said case. Because if we grant the bail to the Mr. Ramesh Sharma, he will hamper the evidences that are there, and he might he might use the connections of his in the police department and in the either connections of political to hamper the evidences and to hamper the witnesses that are there.
What is the case against him?
He had done the criminal conspiracy, kidnapping and murder under Bharatiya Nyaya Sanhita, section 61, 103, 314 and section 336(2) of possession of
explosive on which you are levying the charges?
Because his SIM card and his digital records are found with the suspect who is dead at the time of on 21st of the July 2024 when the prime accused Mr. Arvind Kapoor found to be dead, the Prakash Kumar found to be dead near the river Gurgaon, allegedly killed, and criminal conspiracy was done, and he was in a contact with Mr. Rajesh Sharma, and both are doing conspiracy against the Ramesh Kapoor, who is the billionaire. If we are not protecting the billionaires in our country, then how we are going to save the common people in our country? So I
think it should be the other way around. It should really be the other way around. I think we just got swayed away with the idea of protecting billionaires. Because some of these billionaires have their own force, no? They have those commandos.
Even though they are having commandos, even though they are having commandos, they are having the self-protection mechanism. Then too, the one corrupt police officer is forcing and indulge with the SUV car with having 20 plus relatives at their residence. It is the heinous of the heinous crime. If we consider
why heinous of the heinous crime? What is so heinous about this crime?
If the billionaire person was going from,
I can understand if he keeps RDX below his house, then it can be heinous because it's a possibility that it may explode. These are genetic sticks which are there, which cannot explode without a detonator also. How can you term it?
There is a
you can say that there is a conspiracy.
There is a threat note also kept with that.
It's not a heinous crime.
My lord, it is not heinous crime according to you, but there are under Article 21 of the Constitution, the right to life and personal liberty of each and every person is protected in this country.
Are you arguing for them? Now it's very clear. They are arguing your case and you are arguing theirs.
My lord, Article 21 not only guarantees the right to life and personal liberty to the person who is accused, but who is convicted, who might be convicted. But the person who is billionaire, his life is also threatened. The person who are protecting his life also their life is also threatened.
I am not able to understand this sufficiently.
My lord,
what is your case against him? Why do you want to keep him in prison? Come on, tell me that.
Because the Rajesh Sharma was having charge under the criminal conspiracy and the wrongful confinement aiding to in murder. The special court in Delhi has also rejected the bail of the applicant because knowing the fact that Prakash Kumar's murder was done by that person itself. That was done.
Why do you say that Prakash Kumar's murder is the culprit?
It was the judgment given by the special court of Delhi.
No, it was not a judgment. It was a judgment rejecting his bail. Nothing more.
The NIA and the petitioner wants to turn to the approval, but if we grant to turn that petitioner to be an approval,
what will happen?
That will happen to the wrong precedent to the judicial system of the.
Does the prosecution fear that he will expose everybody? Is that the case?
That is not the case. But if we grant him bail on the ground of making him a turner of approval.
Why not in so many cases if somebody says that he is turned an approval, we do grant him bail? Why? Because he is aiding the prosecution.
But he had done so many wrong things, such as he had done the criminal conspiracy. He had used the SIM card which was used during that criminal conspiracy and that matter of.
Is it good enough to buy SIM card and be prosecuted and be behind bars? Buying SIM cards on one side, using them in a conspiracy, you are not telling me. But on the other hand, he is in jail.
Yes.
All that he is saying that please bring me out, I will cooperate with the investigation, put me to any terms. So, what is your objection to that?
My lord, our objection is that why can't he are cooperating with us now when he is in bar? So he should cooperate with us. If we grant him bail, he will float away and he will go to another country, and how will we get him back?
What is that called? Using your flight risk?
Yeah.
What is that test called? In the recent Supreme Court judgment. It is known as the tripod test. In Govinda Singh versus State. Recent Supreme Court judgment is there. Govinda Singh versus State of Punjab.
much obliged, Your Honor, for letting the counsel to aware the fact of research.
What else material do you have with him?
If we grant him the bail, that will hamper the investigation along with the evidences that we have kept against that person.
वो क्या करेगा? चोरी कर देगा?
He is one of
with the witness evidence. He influence the witnesses.
He has the police background with multiple times of he was dismissed and he was.
I understand all these things are okay against granting liberty to a person. Can that be? If you are keeping him in jail, try and understand. तुम्ही एक दिवस तुमच्या घरामध्ये जरी राहू शकता ना, फक्त होळीच्या दिवशी कदाचित राहाल. त्या व्यक्तीची बाहेर तुम्हाला कोण कलर लावतील. He is in jail. His freedom is gone.
His freedom is gone because of the due process of law that was done under section 43(5).
Has he been proven guilty? Tell me.
Sir, prima facie evidences are such which are political.
Tell me what are those prima facie evidences? 1, 2, 3. 3 evidences. Come on.
That abduction and murder of Prakash Kumar on 18 July 2024. Prakash Kumar went missing. His body was found.
Prosecution case. What has he done to keep him what has he done prima facie?
The call detail record showing Sharma's frequent communication with prime accused Arvind Mehta after and before the abduction.
One you have answered is to purchase SIM cards. Nobody will purchase SIM cards like bananas, right?
Yes, Your Honor.
1.25 डजन बनाना दे दो, 15 बनाना का खर्च आता है. वैसे 15 SIM कार्ड दिए हैं.
Witnesses' testimonies confirming that Sharma was present at a key meeting where the conspiracy was discussed.
This is the second. And what is the third thing?
Internet protocol, IP logs, and digital evidences indicating the CDRs and evidences. Sharma procured SIM cards used by the accused.
You are the only speaker in the team, or is there a
co-counsel is there. I will take up with few issues and
just see that you earlier took a time limit. Otherwise, your counsel will not get time.
Yes, Your Honor. Whether petitioner's active role in conspiracy justifies his continued detention. Petitioner is directly involved in the crime. NIA investigation has established a clear link between the petitioner and the conspiracy. Evidence against him includes the CDR, the call detail record showing frequent communication between the co-accused and the witnesses' testimony, which are proving that the Sharma was allegedly involved in that particular scam, along with as per
scam नहीं,
crime.
Scam अलग होता है, उसमें ये होता है.
Here might be one of the link of the threatening to that billionaire to get out the money. So it may be one of these scams that NIA wants to further produce and further investigate from that particular accused. My co-counsel will go ahead with further research.
Please adhere to your time. वो जरा माइक नीचे कर दीजिए मुझे.
Okay, I will go on issue number question 3. Whether the petitioner offers the delay of the petition the delay acting or not.
Whether the petitioner's right to fair trial. Which issue are you arguing on?
Number 3. Whether the petitioner offers to turn approval under section 772 of BNSS is a delay.
That is issue number 4. Whether the petitioner offers to turn approval. Under section 272.
Yes.
That issue you are arguing? Yes. Why are you rejecting his offer?
So because looking at this.
You can argue in Marathi, Hindi, also.
No, I'm talking
about
okay, looking at his career and his allegations that were there, the way he was falsely.
He was a police officer.
He was a police officer and was repeatedly involves a certain crime. So there is no guarantee that even if he turns an approval, he will not revert back to the same. Because he has done repeated times, this is not the first and the last or the last. There is no guarantee in such.
Therefore, you are rejecting.
Yes.
But don't you think, suppose if he turns approval, he might disclose everything about Arvind, that the main man, the main conspirator, who is that? Arvind Kapoor? Arvind Mehra. He will disclose everything about him. Is that not a good enough carrot for the prosecution?
Sir, but then if Arvind Mehra was already suspended and this person has listened and related to him and done what was asked from him from a suspended officer, then how can we say that
that is for the prosecution to decide, not for the court. Yes, next. Don't be sorry, you are doing very well. Don't worry. You are doing very well. It's not easy otherwise to face questions like this. Otherwise it will be a monotonous exercise, it will be an elocution competition from morning 9 o'clock onwards. We can't afford to have that. This is the way we test you all.
So because when we are referring to certain cases and all that, we also look at the history of the person. And these two people, Arvind Mehra and Rajesh Sharma,
civil parlance it is known as antecedents. These antecedents are such that a court should not rely on them.
Exactly.
Rely for
They
it.
were police officers and they have mishandled and misused the power that was given to them. So we cannot tell them that they will not go through in the future also.
Next point.
Whether the application of UAPA and DNS 2023 is justified given the national security implications.
Yes.
Okay. The case involves terrorism related offences under UAPA.
When you are arguing your case, I should understand what you are arguing. Very fast, you are murmuring in your mouth only. Be very precise. No problem. Otherwise I can hear everything. I can hear everything what your co-speaker will say. Speak. Okay? Speak fluently, clearly, and slowly.
So whether the application of UAPA and DNS 2023 is justified given the national security implications. The case involves terrorism related offences under UAPA. So the presence of explosives near an elite businessman residence suggests a larger terroristic conspiracy. Now we get to know the fact that this vehicle that was found was not in the billionaire's home. It was on a public road. It was parked on the public road. Had it not been found and had the conspirators been successful in their attempt, it would have been a case of mass terrorism. Because it would have involved the public, because it was parked on the public road.
Had it exploded.
Had it not been found.
But the problem here is, according to the prosecution case, there was a note which was found inside. And the note, there was a threat note given to that video.
Even though the threat note was on Mr. Kapoor, it may be a hoax or whatever, but it still carries a threat